Well, good morning, everyone.
Good morning.
On behalf of Judge Karopkin and Judge Bazzi, I'd like to welcome everyone to our first of 2 days here in Grand Rapids for case call. It's a little unusual. We're starting today at 9:30. We typically start at 10 o'clock. That's because we were informed by the Farmer's Almanac that it was supposed to snow today, but apparently they missed it by a few degrees and snow became some rain. So there you have it. That's some background for you. Why don't we, I know we have some remote and we had some remote.
Yes.
Okay, terrific. All right, well, let's call our first case, People of the State of Michigan versus Golder. That's item number 373826.
We were informed this morning that Ms. Margosian is having equipment troubles, so she is waiving oral argument.
All right, thank you very much. In light of that, the matter is submitted. Turning now to item number 2, that's People of the State of Michigan versus Schmitzer, 369107. Looks like we have both parties arguing remotely.
Yes.
All right, Miss Young, go right ahead.
Good morning, Your Honors. Laurel Kelly Young on behalf of Mr. Schmeitzer. And I feel that I have adequately briefed the issues regarding whether or not he had voluntarily waived his rights regarding Miranda. So if you have any questions.
All right, I don't see any questions. You've got plenty of time for rebuttal. Mr. Babcock?
Good morning, Your Honors. Russell Babcock. I'm here on behalf of the people. We did file a written response to the brief on appeal. We would rest on our brief as far as the arguments that were raised and responded to. And we merely, if Your Honors have any questions, that's basically where we stand, Your Honor. We'd ask that the lower court's decision be affirmed.
All right, I don't see any questions. All right, Ms. Young, did you have anything further?
Nothing for rebuttal.
Well, thank you both for arguing remotely. We will consider the matter submitted. Turning now to item number 3, People of the State of Michigan versus Riddle, 369716. Ms. Young is arguing remotely.
Yes.
Proceed when you are ready.
Okay. Well, this is a really sad case. As I know you must see from the transcripts and the brief, he struggles with severe mental issues. And what I just wanted to impress upon the panel is that his intent was not to set the correctional facility on fire. His intent was to set himself on fire. And that, so the element of intent was not there.
All right. Thank you very much. Ms. Nelson?
Thank you. Good morning. Jenna Nelson on behalf of the people. I had filed a written response to the brief on appeal. I will rest on that brief and I'm happy to answer any questions.
All right, I don't see any. All right, Ms. Young, anything further?
No rebuttal. Thank you.
All right, thank you both very much.
Thank you.
Thank
Welcome.
you.
The matter is submitted. Turning now to item number 4, People of the State of Michigan versus Milstead, 375953. Don't show anyone arguing remotely. Is that correct? All right, then go right ahead.
My name is Kyle Butler. I'm the prosecutor for Ionia County. I represent the appellant. I'll be the only one arguing on behalf of the appellant today. I would request 3 minutes in rebuttal. I'm not sure if I'll need it, but would request that.
All right.
There's a few things that I would like to highlight for the court today. We've submitted the briefs. I know your honors are familiar with that. But the first thing I want to talk about is the CREST fourth condition not being met. Namely, it's not being met because this new evidence that the trial court relied on does not make a different result probable on retrial. Second issue I want to talk about is that the trial court abused its discretion in finding that the fourth condition had been met. It abused its discretion in 2 ways. 1, it relied on incorrect facts, and 2, it relied on improper facts. And we'll talk about that a little bit more too. And then lastly, I want to talk about what the case of People v. Rogers shows us about this type of situation, a new trial being ordered, and then the evaluation of the CREST factors in that case. And what we learned from that, and I'll get into it more in a little bit here, is that the trial court can be found to have abused its discretion in the application of the CREST relating to recanting statements. And that case also, what it did was help demonstrate indicators that would support granting a new trial in light of the 100-year precedent and judicial philosophy to look upon recantation evidence with suspicion. Now, focusing on my first issue here being the CREST test and the 4 conditions, people do concede the first 3 were met, so we're just focusing on the 4th. Now, if you look at the trial court's analysis, when it talks about this 4th factor here, the 4th condition, the very first thing that the trial court focuses on is something that's not relevant to the matter. And that is, she is quoted as saying, quote, "You can pretty much get a child to say anything you want that child to say." That's the first focus that the trial court judge had in this case when analyzing the CREST. The second focus then right after that was focusing on frankly, the interview that the stepmother had with her stepdaughter after noticing that something is amiss with her stepchild. And then she decided to record that interview to preserve it. And the judge characterized that as being pressure that was placed upon the victim by her stepmother. So the judge is already focusing on 2 points right off the bat that don't have anything to do with the evaluation of the 4th condition in CREST.
I'm going to stop you for a second.
Sure.
Isn't that part of the CREST analysis? You're looking at all the evidence that was admitted in the trial and taking into account the new evidence. And in conjunction with all the evidence admitted at trial, would a different result be more probable on trial? And so is it an error for the judge to focus on the evidence at trial? Isn't that what the judge is supposed to do?
I think the primary focus should be focusing on the new evidence that's being purported, that's being admitted for the motion for new trial. I think that's the primary focus. Now, obviously, she can't ignore the facts that came out in the trial, but I think that the primary focus really ought to be, okay, what is this new evidence that's coming out, and then how does it relate to the materiality of the testimony at the trial?
Well, isn't that what she does? But she does it in reverse order. And so are you saying the order in which that the judge presents or judge goes over the evidence is important to the analysis? I mean, as long as the judge is going through the new evidence and then also discussing the evidence at trial, what does it matter that she starts with the evidence at trial and then goes into the remaining evidence? So I guess I don't see how that was the primary focus, but rather one of the focuses.
Sure, I understand. But I guess I would respectfully disagree when the judge is leading with this focus. It appears appears to be her primary focus in this matter.
Well, let's present a hypothetical.
Sure.
Suppose that the original trial evidence was presented through videotape proof that the sexual assaults had occurred. And then later on, the complainant, the victim recants. Well, then, the trial judge should consider the fact that there's videotape proof that the offense occurred in deciding whether or not the fourth Crest factor was met. Here, it's kind of the extreme opposite. It's a credibility question involving a young person who was audio taped talking about the situation, but it sounded like there was pressure being placed on her. Seems like that those things are material, in addition, of course, to the new evidence that needs to be considered.
Right. And so what I'm focusing on here is that, and I agree with your honors that you have to look at what came out at trial. And if we look at the prior cases, the Grissom and the Crest case, the court really focuses on what came out of the trial when it determines whether or not it's going to order a new trial in the case. But the primary focus has really got to be, what is this new evidence? How credible is this new evidence? And then you move into the secondary as to how it dovetails with the evidence that came out when it comes to determining whether or not this evidence would result in the probability of a different outcome. Okay, so now these 2 points in the people's opinion demonstrate the trial court's personal reflection of the trial testimony and the trial court's personal interpretation of that, colored by an overly broad conclusion from some judicial conference. All right. In that you can get a child to say anything. And even if that is true, let's say it is true that you can get a child to say anything, then why didn't that bear true during the trial? Why didn't that bear true during the preliminary examination? Why didn't that bear true when we have Heath Lynch, who maybe some of you who are familiar with, a very experienced trial attorney who represented the defendant from start to end, much like I represented the people from start to end in this case? Why is it that an 11-year-old child that has a borderline cognitive disability, who has a 504 plan, who has special needs in school, is able to withstand rigorous cross-examination? Okay, so the trial court is relying on this statement from a judicial conference that you can get a child to say pretty much anything, but then we have her withstanding this cross-examination, not only at preliminary examination, but then also at trial. Mind you, trial, she was on the stand for 3 hours. Preliminary examination, she was on the stand for just over an hour. Now, neither point that the judge decided to initially focus on had relevance in the application of the Crest factors, being that the evaluation of the actual new evidence. It's not. And instead, she's not putting herself through this reasonable juror lens that she ought to be, but instead she's looking at through her own lens. Now, furthermore, the trial court focused on incorrect facts to then support the new trial. The trial court states that ESG, the minor in this case, indicated to her mother, at least 3 individuals at Pine Rest, the right door, and then Dr. Sanchez, that she had not been truthful at trial. This is not what the evidence bears. It's not what the testimony bears. And she says right after that, and follows, so that combination, so now she's focusing on just that combination of incorrect facts, all right, really does preponderate towards a likelihood that there would not be a guilty verdict. And the problem for the trial court is that it didn't cite these correct facts. ESG did not tell her mother, okay, it was her stepmother, all right, 1. Minor, but it is a different fact. Second, she did not tell at least 3 individuals at Pine Rest. There's nothing to support that. She told 1 person, her stepmother, and then she made a comment to Dr. Sanchez, who works for the right door. All right. And these comments that I'll get into later simply don't even rise to the level of a recantation of the actual facts that she testified to at the preliminary examination, the 2 very detailed incidents being in 2 very separate places, and the facts that surrounded all of those, who was there, who was not, what was happening, what the defendant said, things of that nature, and then doing the same thing at trial. Now, we also can't forget that the timeline of this case, and this is something that I just want to skip to, because sometimes the transcripts don't really lay this out as clearly as those who have lived it. So in February of 26th of 2023, the victim discloses and her stepmother records. The next day, the police are contacted to report the incident. And then just days later, on March 1st of 2023, there's the Child Advocacy Center forensic interview that's performed. 2 weeks after that, we have the Center for Child Protection evaluation performed by Dr. Sims, which is customary in these types of cases. And then on April 12th, we have the preliminary examination beginning. Now, the people had started that preliminary examination in the effort to try to keep the 11-year-old traumatized, fragile victim off the stand, all right, in order to bind this case over. However, defense counsel objected to that strategy, and Judge Vogt ordered that we adjourn the preliminary examination and that the victim actually appear to testify. So we did that on April 17th. And so the direct examination started at 4:42 and the prelim concluded at 6:14. So 1.5 hours of approximate testimony by.
Why does this matter?
Why does this matter? Because what we have here is argument by defense counsel in their brief when it comes to these inconsistencies that they're trying to shows that the victim is not being credible. Okay. The passage of time helps to support the inconsistencies in this case.
The strongest evidence that she wasn't credible is the fact that she later told her therapist that she lied.
About what?
The medical record says complainant openly admits that I lied.
About what?
About defendant abusing her.
Well,
Isn't that
that's,
what the medical record says?
I don't believe that's what it pans out. And she does not specifically recant the two instances.
Whether
That's,
it seems as though you're stressing that this is not that the victim in this case did not recant, but you have to at least acknowledge that there is a substantial amount of new evidence that is useful for cross-examination had it been available that might justify a new trial. I mean, you can argue that this may not, I lied, may not mean I lied about the sexual assault, but it sure seems as though that is a reasonable interpretation of what she said. And why wouldn't that be fodder for cross-examination?
Certainly, it could be fodder for cross-examination. I understand that in certain instances. It may not always be fodder for cross-examination. It may be suppressed. I'm not sure how any of this information really comes out in trial in the grand scheme of things. When we're
Come out as impeachment evidence?
well, it could come out as impeachment evidence, but we're also talking about federal laws here, HIPAA. That was another reason why Dr. Sanchez didn't talk about everything that he was asked to be talked about in the motion for new trial. That's also a reason why I couldn't grant him immunity, which defense counsel brought up.
But wouldn't there be an exception if the evidence was impeachment evidence? Couldn't the trial court find that it would be admitted if, as long as they can show that it's impeachment evidence? And frankly, when she's saying she lied, wouldn't that be impeachment evidence?
Well, it depends on what she's saying she lied about, and that's what we don't know. That's what we don't know. We don't know what she lied about, okay? We don't know what she's saying she lied about. We don't know even the credibility of that statement in and of itself. Because what we do know, what was bared out in the testimony for the new trial, is that ESG was very reluctant to go to counseling, okay? She did not want to go to counseling.
Well, she said that she told her stepmother, allegedly, I was not assaulted.
Okay.
Correct?
Yes.
Okay. What do you make of that? Why isn't that, well, I would call it, would you agree that that's recanting? Are you not willing to concede that?
That would be a recantation of something. I don't know what.
I was not assaulted?
Yes. Because she also indicated that she was physically assaulted by him on other times, by him throwing things at her, okay, and doing things to her.
Okay.
Which is totally separate from this criminal sexual conduct. All right. So back to my timeline. So what we have here is we've got a child who's going through this situation here, which then she testifies at trial nearly a year after the preliminary examination about incidents that happened to her up to 5 years prior. Okay, so obviously there's going to be some appropriate inconsistencies in an 11-year-old statement, okay, and recollection about this situation, right? Now, going back to the recantation, now it's simply speculation that ESG is actually recanting this specific situations that she testified to in such great detail, that the preliminary examination, that the magistrate, then Judge Vogt, agreed with the people to add 3 more charges of criminal sexual conduct in the first degree. Testimony that was so credible that Judge Vogt indicated when addressing defense counsel, saying defense counsel has described her as confused or unreliable, but I can say that my impression is that she provided a lot of sophistication and detail.
Why does this matter? Why does it matter what Judge Vogt, a district court judge, his assessment of her credibility? Why does that matter?
That's what this is all.
Your client, the defendant was convicted beyond a reasonable doubt based on her testimony.
Correct.
That's the beginning and end of the credit, as far as I'm concerned, that a jury found beyond a reasonable doubt that she was credible. That's it. I don't think we have to reach back to a preliminary examination, district court's judgment about adding counts. That seems to be an unnecessary stretch that you're making.
Okay. Well, I understand that your opinion on that, but I do think that it bears relevance here in this case, particularly when you compare it to what we see in Rogers. Okay. And with Rogers demonstrating what we have to have, what needs to be shown, what can be shown to order a new trial. And when you look at all the evidence in Rogers, it is overwhelming that ought to be granted, a new trial ought to be granted in that case. Audio, recorded statements by the victim, specifically recanting the specific instances, signing an affidavit to the same effect, okay, testifying under oath. We don't have any of that in this case.
Isn't Rogers the rare case where you'll have all of that? I mean, in order for Rogers to have occurred, the prosecutor's office had to give immunity to the victim to come up and say that. Otherwise, there would be perjury implications. So isn't that kind of the rare case in which you have that type of evidence? And doesn't Grisham indicate that while recantation evidence should be looked at in a particular way, it's in the rare case where the impeachment evidence strikes at the heart of the material evidence at trial that the court should not decline to consider it?
I'm so glad you brought this up, because that's my question to you. Is this the rare case in which an ambiguous statement by ESG triggers a complete reversal of everything in a new trial? Those cases indicate that it is going to be the rare case that happens. And that shows, Rogers shows us how rare it's got to be and how much it's got to come out.
Well, don't the medical records, the psychiatric records specifically state EJS openly admits that I lied about Taylor abusing her and I don't care when discussing that he is now in prison in relation to this?
Again, I don't know exactly what it's hearsay information, first of all. Okay. And Dr. Sanchez did not elaborate on that. He refused to elaborate on that. And that's the issue that we have. And so, my question
Is there any question that had that evidence been available before at trial, that would be usable as impeachment?
the defense certainly would try to use it. Absolutely. And if I was in their shoes, I would try to as well.
But you're not sure if it would come in?
I don't know exactly. I don't know exactly if it come in, because I think that we've got layers of issue here.
Would you oppose it? Would you oppose the admission of your witness specifically stating allegedly to the doctor, I lied, I made it all up? Would you oppose the jury hearing that?
I would be careful with it. I would be very.
I mean, this is not a helpful dialogue we're having here, because you're not answering questions.
I'm doing my best.
Okay.
Right. And I don't operate in a vacuum. And there's a lot of variables at play here. And so would I oppose it? I would have to look at what the defense is arguing, what theories they're trying to get this in under, and then I'd have to look at the many layers and peel it off to see, okay, is this something that lawfully should come in or not? I don't know the answer to that off the top of my head. We haven't encountered that.
I mean, don't we kind of have to make that evaluation at some level in order to decide this case?
Well, I don't think the court works in hypotheticals. You need to work with facts. And that's what I try to do as well. Because
But Cress requires us at some level to work in a hypothetical, because Cress demands that we make an assessment about whether, if new evidence were to come in at a hypothetical new trial, there's a reasonable probability that the outcome would be different. So stepping one step back from that, we have to decide, I think, is this evidence that's being presented likely to come in at a new trial? And I guess, so it seems like an important question for us to answer, or for us to know your position.
sure. And I don't recall the trial court judge making that analysis as to whether or not it would come in at trial. So again, that goes to the judge, my point in that improper and incorrect facts in the analysis of this case, of the facts that came out, and applying it to Cress, and whether or not this is one of those rare cases in which the people are going to characterize it as ambiguous recantation. Okay, we don't know what she's specifically recanting.
So I don't recall whether you said you wanted 10 minutes or 5 minutes on rebuttal.
I said 3, I believe.
Okay, so you've got 8 left, so go
Okay,
ahead.
okay, wonderful. So let's see if there's anything else that I wanted to touch on that we did not. Oh, I wanted to talk about those other acts. So the other acts involving the 2 school incidents and the father's treatment of her, those other acts are immaterial, okay, to the actual offense at hand. The other acts being the 2 school incidents, they're not related to any kind of false CSC allegation. They're related to contact with another student, consensual contact that ESG is alleging had occurred. Okay, that apparently was never investigated by the police. That was simply summarily just dismissed by the school in that case. All right, and then we have the allegation that she had apparently indicated that her father, her biological father, had physically abused her in some way, shape, or form, and that turned out to not be substantiated. Okay, now those have no relation really to the allegation that ESG made about Taylor Milstead and what he did to her. Okay? That was forcible sexual contact on 2 incidents, completely different than the other incidents that were alleged. And so I'd just like to say that there's no proof so unreliable as recanting testimony. In the popular mind, it is often regarded of great importance. Those experienced in the administration of criminal law know well its untrustworthy character, a 100-year-old precedent. This is not one of those rare cases in which this very scant evidence ought to overturn a jury of 12's decision that the defendant is guilty of all 7 of the charged counts. Thank you.
Thank you.
Good morning. May it please the court. My name is Robert Wellman. I'm representing the appellee. Very rare that I get to sit on that table. I wanted to address a few things that Mr. Butler brought up in his argument. One was he mentioned that Dr. Sanchez wouldn't testify because of HIPAA. I think that's, and I'm not sure if HIPAA has criminal sanctions in it for violating that statute. If it does, I think that's what Dr. Sanchez was referring to. He didn't want to testify under a fear of self-incrimination. And I think that's important because one of the points that Mr. Butler is bringing is we don't have any first-hand evidence of a recantation of the victim through that doctor because he wouldn't talk about it. Mr. Butler, as a prosecutor, has that authority to offer immunity if that's the case. And he didn't do that at the hearing. So I think that should be something this court consider, that he didn't bother to look for that information. And instead, he wants to claim that there is no information, no evidence. The other point I would like to address is, I think you've been asking Mr. Butler about whether this evidence can come in a trial. I think it does, because impeachment evidence. It's also, the medical records also indicated, I think, proof of motive and intent for wanting to lie, and that can come in as well as evidence. And again, if Dr. Sharon had called the trial, I certainly would have subpoenaed him. But if he continues to exercise self-incrimination, I would also remind the court that the prosecutor has the burden of proof at all times at a trial. So to further claim that the trial at a jury later on to say there's no proof of this statement, I don't think you can do that.
I have a question for you related to the other act's evidence. Shouldn't the judge have conducted the Hackett analysis on all three pieces of evidence separately? And wasn't it hearsay upon hearsay? She just accepted the testimony of what the stepmom told her, what somebody else told her.
Okay, are you referring to the school?
The school, the two incidents at school and the beating, the alleged abuse by the father.
Well, I think that should come in as impeachment evidence. And again, do we actually admit evidence of that? No, you can, I think the standard practice is to ask the witness if she remembers alleging those sexual assault. And she can say yes or no. And at some point you could, bring in a rebuttal evidence.
The Hackett indicates that there's supposed to be an in-camera hearing related to the other act's evidence, and it's defense's burden to bring that evidence. And so it's not just impeachment evidence that you can ask the witness while they're on the stand. There's an entire procedure. Was it error for the court to consider that without going through the proper procedure?
So we're determining whether or not it could come in a trial. The fact that we didn't have evidence of, the school records, I think that's a problem for the defense attorney, because that is protected information. So I would imagine if this new trial were to go through, we would have to do some sort of motion, like a stand-away motion for those records for the education. So, and I think, again, if they understand that stand-away, I think they would be material and they would have to be produced, same way as the medical record. Because we're talking about lying about sexual assault. And I know the stepmother said one was consensual, but it's still lying about being a sexual encounter. And I think that is still relevant. So if they were allowed to be at least produced or a stand-away motion, I think there can be further investigation done. We can find out witnesses. You can interview those witnesses could come in. So I'm thinking school official that investigated.
I guess my question to you, when determining the court in a new motion for a new trial under Crest has to make a determination about what evidence would actually be admitted at trial and consider that with the evidence already presented at trial. Was it error for the court to consider that evidence before a finding was made, whether it would even be admissible?
No, because I think somebody here, one of the justices mentioned a hypothetical. So, and I think the trial court would engage in that same hypothetical. If I can, go through the stand-away. I think Roger's request also discusses quite a bit about, how do we analyze that, whether something can come in or not as evidence. And I think one big takeaway of that is impeachment evidence is that part of that analysis. So even if we're talking about evidence that may ultimately not be admissible, if it's evidence of credibility, yes, that would come. I mean, again, the practice is to ask a question of that impeachment on cross-examination. Okay. So, and again, I just remind the court that this is an abuse of discretion standard, and just a mere difference of opinion about whether, you can have different principal outcomes, different principal decisions on whether to grant new trial based on all the evidence. And I agree, it's all the evidence, not just focusing on what was already presented at trial, but the new evidence that we didn't know about. I don't think Rogers holds that we're talking about a certain quantum of evidence or affidavits that were submitted or the number of witnesses that heard the recantation. I would point out the procedure posture in that case was different. That was the case where the trial court actually denied the motion for new trial. And then the Court of Appeals reversed that. Here, we're the opposite. Just to compare Rogers a little bit, and I think Rogers did it right because they're talking about analyzing that fourth factor of undercrest. What is there's a probable different result. And that's the whole thing. They're saying in that case, yeah, we rated the probable cause. There's a lot of discussion about how it could go either way. Like you can analyze certain, like for example, this witness recanted several times. She recanted her recanted statement. And there's a lot of ways to look at that. So the court looked at that and said, well, sure, the jury could just disregard it, kind of the same way that the trial court did, but they could also say that that means he was lying. And because of that, it's not, I don't know if they consider it equal possibility, but they did say that would be enough to say it's probable different result. So again, Rogers also citing Crest made it clear that the trial court had discretion to evaluate the witness credibility. So in this instance, the trial court did observe the witness, the complainant, for the entire trial, and that can be a part of her evaluation. But again, it's when you do the evaluation, it's from the reasonable juror standpoint. So again, is it reasonable for a judge or a juror to conclude that the witness was not credible? And again, all the evidence. This is similar to Rogers in a lot of ways. The important way: no physical evidence, no corroborating evidence, no other witnesses. And Rogers, there was actually an other acts witness. They also claimed she was sexually assaulted by the defendant. In this case, we don't have anything like that. And then I think there was some mention here about, again, the line about sexual assault at school and line about physical assault about the father. Rogers actually pointed that out, and they said those are admitted by us the same kind and similar circumstance, and they had a powerful way of discrediting the witness. So I think in that way, it's pretty similar to this case. Motive and intent, I think there were also things that we didn't know that weren't used by the defense attorney in the trial because he didn't know about it. Why would she lie about these things? Well, one is she was hoping a biometric would kill one. I mean, I don't know how powerful emotion that is, but that wasn't something that we could use or present to the jury. Attention-seeking behavior, that's pretty obvious in the medical records that she has that issue. Again, we didn't have that evidence. I think that's really disconcerting to me in this case, is that this was all the information that was known to the stepmother and the father before the trial. And you never revealed it to anybody. At the motion hearing, I didn't find the stepmother credible because I thought she was doing a lot of hiding the ball. To my question. I don't know if you can tell them the transcript, but her answers to me kind of differed.
And this is who?
The stepmother. So I don't find it credible. She said it was a vague statement she made about the sexual assault. I think she really did know that her daughter, the stepdaughter, recanted, and they were having issues with that. And they were trying to find psychiatric help for it. But the one thing she didn't do is tell the prosecutor that of these other acts of lying. Significant one.
She told the therapist, is that right?
Again.
The stepmother told the therapist about the other acts?
Yeah.
Is that right? Is that how did it get into the record? It was that the stepmother.
Oh, yeah.
Right.
When we got the medical record, we saw that she was telling other staff about that.
Like, hey, I have concerns. My stepdaughter is lying about a lot of things. For example, this stuff at school, right?
Right. And then also the motion hearing, she addressed that as well. And again, it seemed like she minimized it. Well, it was consensual, wasn't a big deal kind of thing. But it's still fine about sexual interaction, whatever you want to call it. Certainly an underage minor having sex is criminal any way you want to slice it. So finally, Rogers, I think is important in a very important point, an important way, is that that was also a criminal sexual conduct case. It really is a credibility content. You have nothing else left that the jury could use. No physical evidence, no other corroborating evidence. And when you have something like that, new evidence that directly goes to that credibility, I think that's really important here. And I just can't see, I don't think an argument that's been made here that this deciding to grant the jury trial on that basis was unprincipled, was unreasonable. Certainly somebody can believe that that was relevant and that a different result could happen, would be probable. So I would ask the court to affirm the trial court decision on the motion. Thank you.
Thank you.
Thank you. I completely agree that the trial court must determine whether or not this new evidence is even admissible in trial, because if it's not going to be admissible in a subsequent new trial, then how is the fourth factor even met in Kress? The defenses that the appellee point out, those defenses are available regardless of this material. And any type of allegation like this, when we have a child alleging that her biological parent's significant other did CSC, you always have the defenses of, well, they're doing it to get the attention from the mom. They're doing it to get out of that situation and go back to their other biological parent. There's custody issue defenses. All those are always present, and defense counsels are very well attuned to that. Now, and then lastly, just the point I'll make, I can't grant Dr. Sanchez immunity. I'm not a federal prosecutor. I don't work for Laura either. So when it comes to getting him immunity from federal charges, when it comes to any violation of HIPAA, I don't have jurisdiction to do that. I don't have jurisdiction to step on Laura's toes either. So I couldn't do that anyways. And that's the rebuttal statements I'd like to make. Thank you so much.
All right, thank you. All right. That matter is submitted. Turning now to item number 5, People of the State of Michigan versus Sims, item number 371876. Go ahead.
I just proved my point there. I have to move to the other table. So again, I know of course we read the brief. I think it's just comes down to this issue of whether or not there were 2 issues here. The trial court be able to vacate the sentence and resentence. And then the second part, if they were going to do that, whether it could invalidate its CODS agreement. Oh, let me put it this way, that it could not follow the CODS agreement and give Mr. Sims a chance to withdraw his plea. So I think that Stewart, which has been cited, doesn't really give any justification for insisting on physical incarceration as being a requirement that has to be physically incarcerated in order for that to pass out of court hand. There was a dissent in that case, and I think they've also indicated that for various reasons that we don't need to have a physical, in fact, there's increased some holding that we shouldn't have a physical incarceration. And as far as again, the second issue, so let's say the judge could rescind and vacate it because of the incarceration. I don't see any case law that supports his ability to vacate or not give a plaintiff a chance to withdraw the plea, because the misconduct that we're talking about under the court pre-sentencing
So, I mean, I think the two issues kind of go together a little bit in that sense, right? Because if you're correct about the first issue, it seems that then on the second issue, it's after sentencing. But if you're not correct about the first issue, it seems that on the second issue, it's before sentencing. So they seem to kind of line up in that way.
Well, I would argue that this court needs to read the court rule in plain language. And from the way it's wording it, it seems that we're talking clearly before we get to a point of sentencing. I guess for the first issue, we're talking about whether they can vacate it, or still have the power to vacate it. So I would argue there is some separation between that first issue and the second issue, because I think second is one, I think it's the court rule is pretty clear. It's before you get to sentencing, and there was a sentencing. And clearly what not reporting to jail was after that happened. And I know people have also indicated that there was a implication or implied in the plea agreement that you would agree to serve that sentence. But again, that's not really expressly stated in any plea agreement. The judge didn't tell him, you have to report to jail, or I'm not going to follow this agreement. That was not part of the agreement. That's something that we do need to have pretty clear in any sort of cops agreement. So I think the court needs to read that strictly. And I don't think that even with, there's just some implication that you have to report to jail that really serves the interest of justice. I think that's just going to bring more contract law into the plea bargaining process.
Can I ask a question about going back to before he absconds and after the first sentence is imposed, he's given a week, I think, to report, right? During that week, what is his status, legally speaking? Is he still on bond? Is he out on bond until he reports? How should we think about his status during that 1 week interim period?
In my experience working in Bromall, like in trial court, is when they pass the sentence, the judge usually says, okay, bond's canceled, you're now remanded as sheriff. In this case, well, now you're to report to the sheriff. I don't recall if the judge made any remark like that about the status of the bond. So I think that's probably one important factor. What did the judge say about it?
Because it seems to me that if after he doesn't report to MDOC on the day that he's supposed to report, the trial judge, I think the record reflects that the trial judge issued a bench warrant. And I would think that the main authority a trial judge would have to issue a bench warrant is because you've not complied with your bond conditions. And if that's the case, then it means that he was still out on bond during that period, which means that he was still under the authority of the trial court, which kind of distinguishes this case from, I think it's Msevny, I forget how to pronounce it, where the Supreme Court says once the trial court's authority passes out of his hands by his own order, he no longer has authority to amend the sentence.
Right. And forgive me, I don't recall exactly what the judge said about the bond. As far as his authority to issue a bench warrant, again, that necessarily has to be because it's a bond violation. I'm not sure. Again, I haven't reviewed that. Don't recall what that record said. I would say this: if the judge imposed fine and costs and said something like, this is coming out of this, you have a bond, maybe that can be applied toward it, then maybe the bond had been terminated at that point. But I don't really recall if there was other ground for a trial court the issue of bench warrant. I think one is contempt of court, which isn't really related to the bond. So I think maybe it doesn't have to necessarily prove their bond to exist. All right. So again, I think it's the it's an interesting issue, but I think the most of the case law is in support of the idea that we don't really, it's not about physical incarceration, it's about when the judge has actually passed the sentence. So we're talking about the governor's authority to issue consider parole and those kind of thing. And I think if we go down this route, physical incarceration, we're kind of stepping into that separation of powers issue. So I would ask the court to find that the trial court erred in this and vacate the judgment and remand it. Thank you.
Good morning, Your Honors. Heather Blomquist on behalf of the people. I'm just going to apologize for my raspy voice today. My voice didn't want to come to work today. I'm just going to jump right into it. Your Honor, I agree that these issues are very interrelated. And to address your question on bond, my understanding is the defendant's bond was continued, and this would be seen as a violation of his bond when he absconded. And so, yes, the people's position is that the trial court still had authority over this defendant. And unlike the cases that were cited by the defense, that the trial court still had authority, and its authority did not cease because the defendant had not yet commenced his sentence. He hadn't commenced his sentence. He was out celebrating his birthday and then fleeing to Texas. That is not having a sentence imposed upon him. And additionally, this court has previously said the simple pronouncement of sentence does not equate to the commencement, and that's Bingaman. And just because there was a sentencing hearing where a sentence was pronounced with a condition that he has to report in 7 days that he did not meet, does not trigger that his sentence was fully imposed to divest the trial court of its jurisdiction over the defendant. And so with that, the trial court did not abuse its discretion. I just want to emphasize this is an abuse of discretion. And I did place a very large block quote, and I apologize for it, but I think the trial court really went through a lot of analysis on why it did what it did. And I don't think that on this record, it is an outcome falling outside the range of reasonable and principled outcomes. I'm happy to answer any questions the court might have.
I had a question. If couple hypotheticals, I'm interested in how you would answer them. If you had a defendant who is on bond in front of the judge who receives a probationary sentence. Sentence is passed, form is completed, same way the form was completed in this case, correct? And the defendant fails to report to probation as directed that same day and absconds. Picked up the next day, brought back in front of the judge. Could the judge sentence him to 30 days jail, not for contempt of court, but because the sentence was not imposed as you're characterizing it?
Well, so I think that's a wonderful hypothetical, and that actually, that's not something I've thought of, but I think with this hypothetical, what's different than what we have in this case is we have all of the statutes that relate to the circuit court's authority over probation and what has to happen with probation and probation violations and revocations, which that's more limited as to what the court can do as it relates to technical violations or if it's a non-technical violation for absconding. But I think that distinguishes that hypothetical from this case. But ultimately, I do think in your hypothetical, looking at it as stated by you, that the trial court would have authority to modify its original sentence if the offender did not begin commencing his probation by failing to show up for probation as well.
Okay.
Because the probation itself doesn't start until you report to the probation office?
Well, I think that, and this is a bit off the cuff here, Your Honor, so I apologize if there's something specific to the statute for probation that's different than this non-probationary MDOC sentence. But I would argue those by analogy, yes. If he doesn't show up to probation to commence probation, sign his probation order, if he doesn't consent to probation, which this court's well aware probation has to be by consent. If somebody's unwilling to show up and consent to probation, then I don't think that the probation has commenced either.
That would be the misconduct in your mind?
Yes. And I do think as it relates to misconduct, when we turn to issue 2, which I know these issues dovetail, specifically, they define misconduct to include, but is not limited to, absconding, separated by an or. So absconding would fit in this hypothetical as well as this case, or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing.
So a different hypothetical. You've got a in custody defendant who is sentenced for credit for time served, 30 days jail. He's unhappy with the sentence imposed and makes attempts to run out of the courtroom. He's apprehended at the door. I think that's misconduct, right?
It is, but
Okay.
okay.
And then they drag him back and the sentencing judge says, you know what, I think I got my sentence wrong. 30 days, I misspoke. I am going to impose six months jail.
Your Honor, with that, I think that the key distinguishing factor is there had been imposition of incarceration. What's tricky about that hypothetical is whether or not the judge signed the order of judgment of sentence and that, but for purely hypothetical reasons, I think the line in the sand is serving at least 1 day of incarceration on the sentence, which that defendant who had served some credit for time served on that would have. And I think that that's what the case law cited in my brief, I think specifically page 5 here, Wybreck 222 Mish App at 166. The court rule codifies the well-settled principle that the trial court lacks authority to set aside a valid sentence once the defendant begins serving it. Here we have a defendant who never even began serving it. In your hypothetical, the defendant had already served the sentence or a part of the sentence.
So the distinction is had he been out, so he wasn't in jail, but he was sentenced to 30 days jail. And then he ran for the door and was apprehended at the door. As I understand what you just said, under that circumstance, the judge could say, you know what, I got the 30 days jail wrong. I actually meant to say 6 months jail because the sentence hadn't been imposed.
Correct.
Because in my first hypothetical, I said credit for time served, 30 days. He had served portion of his sentence.
Yes.
Where in my second scenario, where he is sentenced to 30 days jail and runs for the door because no incarceration had been imposed, the judge could sentence him to the 6 months jail.
And I think the authority.
Awfully fine line you're drawing.
I agree that it's a fine line, but it's a line that this court and the Supreme Court has drawn.
Okay.
And specifically just in reference to that, I know they're older cases and unfortunately that's what we're left with because this issue, I don't believe has come up much. But I do anticipate that this is an issue where we have virtual sentencings in which offenders are instructed to report to jail or jail to then go to MDOC in the future. I do anticipate this being a potential issue down the road. But looking at the cases and the precedent that's persuasive to this court, albeit, but Stewart specifically says the authority of the trial judge over the respondent ceases when a valid sentence has been pronounced and the respondent enters upon his imprisonment. And I think that's the line, albeit a fine one. That's the line here, and the trial court didn't abuse its discretion by following Stewart.
Any questions? Okay, we're all set.
Very
Thank
much.
you. Yeah, you've got time for rebuttal if you'd like to use it.
The court poses a few interesting hypotheticals, and I wanted to add my own response to that. First one was failing to report to probation officer. I think there's an important distinction there because that is a probation sentence, and the court still has authority to amend a sentence and a jail sentence or a probation sentence at any time, is what I understand. This case was a prison term, it was 5 years at least. So, once that sentence is passed, the idea is that it goes into the DOC has jurisdiction. That would be my answer to that question. No, if, I guess, what was it? There was another one where he runs out of the courtroom. So, and then because the defendant that runs out, but he's in DOC custody, could the judge change the sentence there? The answer to that should be no, because that's what Messervy was talking about. That was what the facts of that case were. But he decided to change it, and I believe that was a prison sentence in that. I believe so. And then the question was that the hypothetical asked to me about could you enter the bench warrant, issuing a bench warrant that shows the court still has jurisdiction. I would ask the court to consider that we did have COVID about 5 years ago, and we were issuing a lot of appellate bond at that time. And so look at whether the trial court had the authority to issue a bench warrant then. If they didn't, they lose their appeal, they're supposed to report back to the sheriff. Did they have jurisdiction then? I think in that instance, the court rule gives them that, because that's what we require in our appellate bond, is that, they exhaust their appeal, they're supposed to report to the sheriff. And then the trial court issues that. So that's where its jurisdiction is. That's actually the order. But as far as whether or not how that relates to this case, I think that's the line of cases that, when we're talking about those appellate bonds would indicate the what jurisdiction. Thank you.
All right, thank you both. Interesting case. That matter is submitted. Turning now to item number 6, Dudley versus Mehmed. Item number 374978.
Good morning, John
Morning.
Steffen on behalf of the appellant Nathan Mehmed. I am well aware that this court reads these briefs, so I'm not going to spend a lot of time going through the brief. I will just highlight again that this was a home that was purchased with premarital funds before there was any contemplation of a marriage occurring. And that my client has made no argument that the plaintiff appellee, Miss Dudley, is entitled to a portion of the funds from the period of the marriage. The big question is, how far back can the lower court go in determining when those funds should be divided? Again, the courts have always recognized that there needs to be a determination of marital property and separate property. In this case, the lower court created a new concept of a joint venture. As I noted in my brief, this was not a joint venture. The risk was borne completely by Mr. Mehmed. The funds paid for the purchase of the home, the closing on the home, were done completely by Mr. Mehmed. And as such, it is hard to argue that Miss Dudley was any way joint in this venture. She bore none of the risk should she have determined to walk away. Also, this home was not purchased in contemplation of a marriage. Parties didn't get engaged until 3 years after the purchase of this home. With that, I would ask if the court has any questions. I'd like to reserve my remaining time for rebuttal.
You've got a lot. Absolutely. Go right ahead.
Good morning, Audra McClure on behalf of the appellee Laura Dudley. I would stand on my brief, Your Honor. I do, Your Honors. I do believe that the trial court made the appropriate decision and that decision should be upheld.
Thank you.
What would be your response to the argument that your client didn't bear the risk of the closure or the mortgage or what have you?
Well, I believe that Mr. Steffen said this morning, he stated that the home was purchased with premarital funds. There was no risk if she had chosen to walk away.
Right. Yeah.
She did not choose to walk away. If she had walked away and the parties had never been married, we would not be here today. She likely would not have gotten any of those funds back. However, the parties did enter into this purchase of the home together. They were looking at homes together. They were talking to the realtor together. They both engaged themselves in the renovation of the home, the cleaning of the home. She paid for the inspection. She paid for the appraisal. She paid for 50% of every mortgage, every utility payment. So it was truly, I know this, I don't think that this is a new concept, but it's not necessarily the legal standard joint venture, but it was a joint venture. The parties did this together. I do agree that a mortgage company, if there had been a default on the mortgage, would not have been able to pursue anything from her. But she was still there. She was maintaining the home. There were various things that happened where she was on the ground involved in maintaining the home. And so from that perspective, there was risk that she was taking on.
She was making mortgage payments with him so that if they had broken up before the marriage and she had moved out, she had put all this equity into the home theoretically and would have, that would not have gotten back to her.
That's correct.
Okay, I think we're all set. Thank you.
I'll waive my remaining time, Your Honor.
All right, thank you both very much.
Thank you.
That matter is submitted. Turning now to item number 7, Estate of Douglas Miller versus Dr. Janja, Janjua, item number 367204. And I believe Mr. Anderson is substituting in. Correct. All right, great. Go ahead.
Good morning. May it please the court. Tali Wendrow on behalf of the plaintiff. I am going to be brief because I know the courts are, the bench is well aware of the facts of this case. This is our appeal from the trial court's grant of summary disposition to defendants after striking plaintiff's standard of care expert following a Dauber hearing. This case involves lung cancer that would have been diagnosed sooner, but for the defendants, Dr. Weeks and Dr. Ross's failure to perform a repeat CT scan. It is our position that the trial court abused its discretion because Dr. Tucker, plaintiff's expert, was qualified. He based his opinions on facts in the medical records supported by literature. And while there's a dispute among the experts as to the applicability of the literature on which they relied, the trial court, we believe, overstepped its gatekeeping role and instead acted as the fact finder. Defendants treated this as a pneumonia case, relying on non-peer-reviewed literature from UpToDate, a website readily used by physicians, to conclude that there was no breach of the standard of care in not repeating a CT scan because Mr. Miller was symptom-free after 4 days. Dr. Tucker, as you know, opined that where the CT report clearly reflected that the pneumonia was a differential diagnosis and not a definitive diagnosis, it was incumbent on the primary care physicians to whom he followed up as instructed to repeat the scan on this patient who was over 50 years old, male, and a smoker. I will note that Dr. Tucker also referenced those demographics in the hearing during the Dauber hearing itself. At pages 30, 44, and 56 of the hearing transcript, he does reference those specific demographics. That was something that came up in the reconsideration order. The experts disputed each other's literature. However, under Chapin versus A&L Parts, courts are not in the business of resolving scientific disputes. Unlike Edry or Eller, which involved peer-reviewed literature and admissions regarding the reliability of that literature, UpToDate is not peer-reviewed, and it's questionable whether it should ever have even been relied upon to override Dr. Tucker's testimony in the first place.
I know you're characterizing this as a sort of a different studies say different things, different experts say different things. Those sorts of contests are resolved by a jury, but it strikes me that the trial court here did something different. That the trial court, for example, if we have a situation where there's a dispute as to whether Roundup causes cancer, all right? You can have different doctors who say that. It seems to me here the trial court said, the literature you're providing, expert, doesn't support your conclusion. Not that I disagree that the opinion you're offering supports the contention that Roundup causes cancer, but instead it doesn't say what you say they say.
And that was because the court, as I saw it, as I read his opinion, focused on a view that what Dr. Tucker was saying was that every time you have an abnormal CT, you must do a repeat CT scan. And I think his testimony was a little more nuanced during redirect and cross. I may be getting that part wrong, but clearly during the hearing, he said, you've got a male over 50 who's a smoker. And you have this abnormal CT scan that shows consolidations, which there was a lot of discussion on that. What does that mean? Could have been nodes, could have been cancer, could have been any number of things. But the point is it was an abnormal CT in this male over 50 who's a smoker. And under those circumstances, and by the way, I also think it's important to note that the doctors, it's unclear that one doctor testified he didn't even see the CT report and the other testified he couldn't remember. So it's unclear that they even ever looked at that CT report, but that's sort of an aside. So while I hear what you're saying, I don't think that, I still think it falls to the question of you've got an expert saying these reports do support my opinion. And there is language in both reports that talks about the demographics. Yeah, you may not need to do, and the one report talks about chest x-rays rather than CTs, but it says you're gonna do these repeat chest x-rays in patients that are over 50 that are smokers that are male. So both studies discuss that, and I think that's relevant to the analysis here.
But the chest x-ray in this case didn't reveal any abnormality. It was the CT scan.
Correct. The CT scans that were part of the records that the PCPs had access to.
Right. But my point is the one study dealt with chest x-rays. And here the chest x-ray didn't reveal any abnormalities. It didn't address CT scans, which is the scan that revealed the abnormality.
Correct, but a CT scan is going to be more precise than a chest x-ray as well.
I agree, but I'm just saying the study dealt with chest x-rays.
Correct. But we're also getting another step away from the fact that the court relied on the up-to-date studies, which was up-to-date, not studies, up-to-date, which is not peer reviewed. So it's question, and as Dr. Tucker specifically testified, that's comparing apples to oranges. That's irrelevant to what happened here. We don't have a patient who had a definitive pneumonia diagnosis. We have a patient who has all these other demographic issues that are a factor that a family physician should consider.
Long-term smoker.
Yeah. Male over 50. And it is incidental that, I mean, it's important that in fact, the cancer it was in the same location where that abnormality on that CT scan appeared. But we have Dr. Tucker saying up to date in this instance has nothing to do with what we're dealing with here. This wasn't a definitive pneumonia, and under the circumstances, they should have repeated the CT scan, and that was his opinion. So for the court to then focus so heavily on the up-to-date article and then negate the other peer-reviewed studies that Dr. Tucker relied on, I think is improper. Additionally, his opinion does not give any credence to these additional demographic factors that Dr. Tucker's whole point that this was not a pneumonia. It was potential pneumonia. I mean, I shouldn't say it was not a pneumonia. could have had both pneumonia and something else underlying. But the bottom line is that they didn't know whether that it was a definitive a pneumonia at the time that they saw him in 2016.
Anything else?
I guess I've got time for rebuttal.
You got plenty of time.
No, that was, let me just see if just to wrap up that, so we maintain, as I've just indicated, that the trial court overly weighted the defendant's theory, essentially ignored plaintiff's expert's testimony with respect to the significance of the differential diagnosis in the CT report, and reversal of the trial court's order granting summary disposition.
Okay, thank you. You got plenty of time for rebuttal.
Good morning, Your Honors. Just to respond to what counsel particularly addressed in direct argument, the issue that the trial court decided was whether Dr. Tucker's expert testimony was reliable. And the plaintiff has the burden of proving that their expert testimony is reliable. So the up to date specifically didn't overweight the literature presented by plaintiff. In fact, what the court decided was that the literature provided by plaintiff did not truly support Dr. Tucker's opinion. And the Craig versus Oakwood Hospital case, Supreme Court case from 2004, establishes that literature provided to support an expert's opinion must truly support that expert's opinion. And here, plaintiff submitted only 2 articles and nothing else. In fact, during his deposition, Dr. Tucker said his opinion was based on his 45 years of experience and common sense. But the 2 articles that were submitted by plaintiff in support of Dr. Tucker's opinions were the McMahon and Tang articles addressed in the briefs. And the court simply pointed out that, number one, the McMahon article addressed nodules, not pneumonia or fluid consolidation. Those are 2 different medical things. It was published in a radiology journal, which has nothing to do with a family medical physician or a primary care physician standard of care. And third, the article says, we do not, quote, we do not recommend follow-up CT for every small indeterminate nodule. And it cites radiation burden and many other potential harms to the patient. So the McMahon article in and of itself is not only inapplicable to the medical issue that Mr. Miller had, but it also says we do not recommend follow-up CT for every small indeterminate nodule. So it contradicts Dr. Tucker's opinion that CT follow-up should always occur when there's an abnormal scan.
I think what we'll hear on rebuttal is that doesn't consider the risk factors. Here, the patient's age, the fact that he's a long-term smoker. What would be your response to that?
Sure, Your Honor. And everyone here, including Dr. Tucker, admits that the guidelines for general lung cancer screening at the time of this medical care in 2016, Mr. Miller was not qualified for general lung cancer screening under those guidelines. Everybody agrees with that. The Tang article, the second article, is what the plaintiff references. And what that article says is, quote, since 98 to 99% of patients will not have lung cancer, we believe routine follow-up chest radiographs, parentheses, other than those for ongoing pneumonia symptoms, end parentheses, are not warranted. So despite the fact that that article says, yeah, it might be okay, as in you're not actually causing harm to the patient to order a follow-up in certain circumstances, it also concludes if there's no ongoing pneumonia symptoms, it's a waste of resources and could potentially cause harm to patients. They're not warranted. That's what it says in that article. So essentially what we come down to is that regardless of these risk factors, both articles the plaintiff submitted are, one, not particularly relevant to the medical issues here. because one deals with nodules and the other one deals with chest x-rays. And secondly, both articles conclude that a follow-up CT or examination is not required when the symptoms are no longer, when the pneumonia symptoms are no longer present.
Can you help me with the nodules issue? There seemed to be a lot of discussion about this, but in the CT report, there was a finding of nodules.
No, there wasn't. Respectfully, Your Honor, there was in the CT report from 2016, there were no findings of nodules. There was focal airspace consolidation. And in fact, the ER documentation from that visit, there's a quote from the patient that says, "I feel like there's fluid in my lungs." And the focal airspace consolidation is a fluid filling the airspace in your lungs, whereas a nodule is more solid density filling there like a tumor.
Can you help me with Appendix 3 to, I think it's your brief, to your appendix, the DeMarco CT report? I think on page 2. Middle paragraph in the findings, there's a sentence and it says there are several bilateral upper lobe sub-centimeter calcified and non-calcified nodules. Am I looking at the wrong report?
I did not bring the full appendix, Your Honor. I'm trying to look for the reference in the brief, but the issue there was the specific findings at the end of the report indicate there was focal airspace consolidation in the left lower lobe of the lung. And he finished that by a differential diagnosis saying it was either a pulmonary infarct or a focal pneumonia. And so there was
That's in the impression section. Right?
Correct.
Yeah. So
correct.
do you have that page? Because right above that, it says nodules, and I'm not a doctor,
Sure.
but that seemed to be a big issue is, are there nodules? Are there no nodules? And the expert maybe was a little confused about that, but since I saw the word nodules, I wanted to see if we could clear up the situation.
Sure. And Your Honor, I apologize. I do not have the full report with me. I have the brief and notes. I did not bring the appendix. I apologize for that. However, I will say that during the Daubert hearing in this matter, I'm looking for it in our brief.
Yeah, I know. The expert says there were no nodules, or whatever. But then if it turns out that there were, and it's in the report, then that makes the literature that plaintiff relied on more relevant, seems to me.
I mean,
even if the expert misspoke during the hearing.
Sure. And I would say perhaps that's one of the three reasons that the McMahon article was not deemed truly supportive by the trial court. However, even if we take that as true, the article does say we do not recommend follow-up CT for every small indeterminate nodule, and nobody diagnosed him with anything as related to those nodules.
What do you mean diagnose? I mean, if it's in the CT report.
It was noted in the CT report. In the impression section, however, it was focused on the focal airspace consolidation and diagnosed the problem this man came in with is either pulmonary infarct or focal pneumonia.
Because I think the McMahon study has a grid, and one side of the grid is for you're not a smoker, and then the other, I'm oversimplifying. One side of the grid is you're not a smoker, and it says how many millimeters is the nodule, and what do you do? And then the other side is you do have risk factors, and then it's like basically all the way down. If you've got nodules, you should follow up. It's either 3 months, 6 months, whatever.
Sure.
And so, I mean, maybe I'm overstating the significance of the CT report that says there were nodules, but it seems like that puts you in that second column in the McMahon article rather than the first.
Your Honor, I would say that that's a little bit of a reach simply because those were simply observations of the CT report. There was no indication in the impression or in the follow-up that indicated those nodules were in any way related to the issues the patient was experiencing, why he came to the emergency room. He said he was short of breath, felt like he had fluid in his lungs. There was a fluid airspace consolidation. They diagnosed pneumonia, and in fact, everyone agrees it was a final diagnosis. I believe Dr. Tucker admitted either during the Daubert hearing or during his deposition, I can't recall, that it was a diagnosis of pneumonia. And he was discharged from the hospital with antibiotics. He followed up with his primary care physician, Dr. Ross, about 3 or 4 days later, and reported that his symptoms had gone away. It was day 4 of the antibiotics. I believe the literature indicates about 72 hours, give or take, is when you would start to expect to see improvement of symptoms. So everything was tracking on the timeline as expected with regard to the pneumonia diagnosis. Therefore, the primary care physician, Dr. Ross, simply said, "It's great that your pneumonia has subsided, and please come back if there's a return of symptoms or any other issues." And in fact, Mr. Miller did go back on 2 occasions following that for a physical exam and for high blood pressure. He declined colonoscopy, he declined blood pressure medication, et cetera. But the point is, he did not complain about shortness of breath or ongoing symptoms related to the lung condition. And, ultimately, this case is very much like the Elher and Idri cases, which are the controlling Supreme Court cases here, in that along with Craig establishes that the literature must truly support the expert's opinion. And here, as the court pointed out, neither of these articles actually support Dr. Tucker's opinion that all abnormal CTs should be followed up, even if the symptoms subside.
And I'm sorry, are you saying that the Tang article is limited to situations where they're continuing symptoms?
Correct. I mean, that it's quoted in the article. It says, since 98 to 99% of patients will not have lung cancer, we believe routine follow-up chest radiographs, parentheses, other than those for ongoing pneumonia symptoms, end parentheses, are not warranted.
Right. But then the next sentence says, instead, our study suggests that the greatest potential diagnostic yield for lung cancer could be realized by restricting routine chest radiographic follow-up to patients 50 years or older, particularly those who are male or smoke.
Correct. And that's like, again, that goes back to the task force guidelines that were applicable in 2016. Remember, the Tang articles from 2011 and the McMahon articles from 2005, and they're actually sort of arguing for a change to the prior standard. As the court noted, Dr. Tucker's opinions were more along the lines of this this older standard or outdated standard. And the 2016 guidelines say that general lung cancer screening is for 55 years old and over, and 30-pack year smoking history. So everyone agrees that Mr. Miller did not meet those guidelines. And so, the recommendation of the author does not, in the Tang article, as far as you can do follow-ups for age 50 and older smokers, et cetera, it was more just trying to get to what is not going to unnecessarily harm the patient. Like, there may be some justification for a follow-up, but it doesn't say that that's required under the standard of care, or that there would be a high likelihood of preventing some kind of lung cancer finding or incidental finding. Again, the diagnosis was pneumonia here, and Mr. Miller came to the primary care doctors 4 days later with no pneumonia symptoms. And it seemed that the antibiotics had worked. So that's the issue, is whether, or Dr. Tucker's opinion was, regardless of whether the pneumonia symptoms subsided, they should have done a repeat CT just because there was an abnormal CT before, and that was clear in the deposition. The nuanced that plaintiff has added has been added, for the purposes of the Dauber here, this Dauber hearing and the appeal, not what he stated in his deposition.
I get that.
Yeah.
Let me just go back to that sentence that I read from the Tang article.
Sure.
I'm having trouble following why you're saying that isn't important.
Sure.
Are you saying that the standard was elevated from 50 years to 55 years after that article came out?
I don't think that there was the same standard. There's no evidence of what the standard was in 2011, and it's really not relevant. The care occurred in 2016, and what the 2016 task force standards indicated was 55 and older, 30-pack year smoking history. So this Tang article, although it says you can, what it's saying is you should not order any repeat examinations just because there's an abnormality in a prior study. But if you have an older patient with a smoking history, you can. But that doesn't.
Well, it says the greatest yield will be if you focus on that population.
Correct.
Plaintiff was in that population, and the plaintiff's expert is saying, like, this supports my opinion that the standard of care would have been to do a scan.
Yes, he is saying that.
He didn't say it at the deposition, but I think by the time we got to the Dauber hearing, he was saying that.
He was saying that, but that still does not. No, again, it doesn't address the fact that this is for the chest X-ray, not a chest CT. And secondly, it doesn't establish any kind of standard of care or recommendation. It's the highest yield, but that doesn't mean, again, it's 98 to 99% of patients will not have lung cancer. There may be a slightly higher yield in that demographic, but it's, again, there's nothing in that Tang article that indicates it's more likely than not, or, it would be a violation of the standard of care or bad practice to not follow up when the pneumonia symptoms have subsided. And frankly, Your Honor, underlying all of this is the fact that cancer does not get cured. So if the pneumonia and some kind of cancer issue were causing these symptoms, like if there was a cancer component to Mr. Miller's symptoms in 2016, they wouldn't have subsided on antibiotics. So everyone was rightfully thinking this was pneumonia, antibiotics fixed it, and follow up as needed. And in fact, after those 2 follow-ups for the high blood pressure, Mr. Miller did not return to the primary care physician for 2 years until he was eventually diagnosed, unfortunately, with lung cancer. So essentially, what it comes down to is that, there's an abuse of discretion standard here. And frankly, the trial court held a Dauber hearing. Everybody submitted literature. The trial court determined that the 2 pieces of literature submitted by the plaintiff were not truly supportive of Dr. Tucker's opinion. Court heard testimony from both defense experts and reviewed defense literature as well. And there was this wasn't a credibility contest. This was just determining whether Dr. Tucker's opinion that the follow-up was required was reliable. And given all of the proceedings below and the trial court's reasoned opinion, it's the appellee's position that the trial court's decision did not fall outside the range of principled outcomes, and the court should affirm it. Thank you.
Okay, thank you very much. Rebuttal?
I just want to take a step back for just a second. I don't know that the court ever needed to hold a Daubert hearing to begin with, but to the question of Dr. Tucker's reliability, the defendants presented the up-to-date data. That up-to-date did not, it didn't render his testimony unreliable as a matter of law. The court wanted to hear from defendant's experts. And again, up to date is not peer reviewed. I'm highlighting that. The discussion that we're holding here about these reports and about what everybody testified to relative to these reports, to the medical records and the literature is exactly makes the point I was trying to make earlier, that this is a question for the jury. I just wanted to point out in the doctor, because I disagree with, obviously with the trial court's assessment of both the McMahon and the Tang articles. In the discussion section of the McMahon article, so this is page, it's our appendix, page 437. It's the Fleischner Society statement on CT of small pulmonary nodules, page 399. In the discussion section, they say, in selected cases with specific suspicious morphology or in high-risk subjects, a single follow-up scan in 12 months should be considered. That's in there. And then later on, it says the patient's age and the presence of comorbid conditions should influence management recommendations. That supports Dr. Tucker's approach, Dr. Tucker's opinion. Likewise, in the Tang article, this is our appendix, page 443, potential yield of chest radiographs. Again, I know we're talking about chest radiographs here, but in adjusted analyses, only 2 characteristics were statistically associated with receipt of a follow-up chest radiograph within 90 days, age 50 years or older. And then it goes on in the comment section. The incidence of lung cancer diagnosed by chest radiographs after pneumonia. That's the section of the paragraph I'm referring to. It states about a third of the way of that paragraph. It's 4 times the incidents were found. That in another study, they found 4 times the incidents that what they had found. And their study, where they found 4 times the incidents, were in male veterans, age 65 or older, group already at very high risk of lung cancer owing to heavy smoking and military related. So both of these articles discuss these demographics that Dr. Tucker discussed during the Daubert hearing as justification for considering a follow-up CT scan. And to conclude, it appears to my observation, my take on this is that the trial court put its thumb on the scale. He wanted to hear from the defendant's experts because they didn't have affidavits at the time they submitted their summary disposition motion, and he wanted to hear what they had to say. They then gave him enough fodder to rule in a way that he, I think, wanted. It's a question of fact for the jury. A lot of these issues that were raised here should be subject to cross-examination. Certainly, there was plenty of ammunition to cross-examine Dr. Tucker's opinions in this case, but his opinions don't have to be unassailable for purposes of admitting them at this point. He was not. I don't think the defendants have established that his testimony was in fact unreliable. And I think the trial court therefore has discretion in so hold. Thank you.
Okay, thank you very much.
Thanks.
That matter is submitted. Turning now to item number 8, Kirk versus Dr. Harper, 375489.
Morning. My name is Rick Grover. I'm here on behalf of Mrs. Kirk, who's the appellant.
That's fine. Is this your client?
Yes.
And that's fine. Our protocol here on the Court of Appeals is if you have a client who would like to go forward to the bar, just let us know, ask us. That's fine. I'll approve it. I'm just letting you know. And anyone else here who has their clients in the courtroom, if you could ask permission before advising. Nope. She keep her right where she is. Just want to make sure we're on the same page. So please stay there. You're fine.
So Mrs. Kirk is my client. She was undergoing a total knee replacement surgery on her left leg. During the surgery, the surgeon, Dr. Harper, shredded her popliteal artery in several areas. There was profuse internal bleeding in her leg. Because of the compression of the bleeding, it injured the most important nerves in her left leg. She's had ongoing therapy and will have ongoing therapy at Mary Free Bed. It's a devastating injury. And her case was summarily dismissed by the circuit court. And that's why I'm here. And I recognize it's a privilege to be here, and I thank you for that. I want to try to put this case in perspective, and I know that you've read the briefs, and I'm not going to reiterate things that are in the brief. But during a total knee replacement, one of the major concerns of any orthopedic surgeon is to avoid injury to the popliteal artery. Popliteal artery is near the area of surgery. And what you have to do in a total knee replacement is you have to saw the tibia so that you can take out the damaged knee and put in a new knee.
And would you agree it's pretty much uncontested that the most likely source of the injury to the artery was the saw?
Yes.
Okay.
Your Honor, that's very clear. And what happened was,
I mean, it's possible it happened a different way, but the most likely
correct,
source of the injury is the saw.
and so what an orthopedic surgeon is required to do during total knee replacement surgery is retract the popliteal artery out of the zone of danger so that when you use the saw, the popliteal artery should not be at risk if you properly retract. You understand that?
Right. When you say retract,
So they use-
it's not something you see in terms of the injury. It's not like seeing a vein in your arm. You know where it should be and you protect it.
So it's when you're sawing the tibia,
Yeah.
popliteal artery is on the back side of the tibia.
Right.
But you use a retractor, you use a device to retract the popliteal artery away from the tibia before you saw. And that's what's required to be done. And Dr. Harper shredded this popliteal artery in several areas. And he knew that before he closed Mrs. Kirk, because he had to call in a vascular surgeon to do the repair.
How did the injury occur?
So, and I will get to that, Your Honor.
I mean, that's the question.
Yes, the injury occurred because of the saw. The vascular surgeon put that in her operative report. She said that based upon the way the popliteal artery looked, it was clear that it was shredded by an oscillating saw. So there's two ways you can damage the popliteal artery during this surgery. You can damage it when you retract it, or you can damage it when you use the saw.
It was a saw.
It was the saw.
Okay.
No question. Now,
Okay.
my point is, Dr. Harper never put anything in his operative report about how he used the retractors or how he used the saw. He knew that he shredded it. He knew that she was close to death on his operating table. He had to call in a vascular surgeon, and he put nothing in his operative report about either of these.
You were the trial attorney, correct?
This case did not go to trial.
No, you're the trial attorney. If this went to trial, you're the trial attorney, right?
Yes,
All right.
sir.
So here's my point, is that this is an appellate court. You've got the delivery of a trial attorney, including the slapping of the
Sorry.
the podium as well, okay?
And I will not do that.
We're not a trial judge, so,
I apologize.
okay. No, it's all right. I'm alerting you to the fact that
Mrs. Kirk is important to me. She's a friend. I'm here to represent her. I apologize. But it's frustrating to me that Dr. Harper doesn't put anything in his operative report so that when I have an expert review this case before we file suit, we don't have any idea how he employed these retractors or how he used the saw. So when we took his deposition, he finally explained it. and we took the benefit of his word that he properly employed the retractors based upon what he said in his deposition. And if you properly employ the retractors, you should not get into this popliteal artery unless there's improper use of the saw. Simple as that. And the way you misuse the saw and the way that you can get into the popliteal artery is that you use a plunging technique. So once you're plunging and you get through the tibia, the plunging technique causes the injury to the saw. And that's where the malpractice was.
So that's what your expert testified to.
Yes,
I just get my question out and then say that's what he testified to. Defendants brought up some literature that said, well, and I'll summarize what my impression of it is. Well, yes, that's definitely one possibility is that you misuse the saw. But another possibility is that there was abnormal anatomy to the artery. And if there's abnormal anatomy, that can also lead to this kind of disaster. And then, now we're stuck with these two possibilities. And so I'm wondering where we go from there.
That's a great question. And I'm glad you asked me that. Because the vascular surgeon that repaired this shredded popliteal artery did not indicate in her operative or note that there was any abnormality to the popliteal artery. Dr. Harper didn't put in his operative note that there was any abnormality to the popliteal artery. There was some mention in the vascular surgeon's operative report that there was some swelling to the musculature, but the swelling, according to my expert, was due to the excessive bleeding. But your question is right on point. And really, that's the only question left after I explain this, that's left for the jury. That's the only question, but it's a question of fact, Your Honor.
The question of fact is, was there abnormal anatomy?
Yes.
That's the question. Okay, that's the question of fact. But isn't there, before you get there, there's a question of reliability as to the plaintiff's expert. And the plaintiff's expert opinion is essentially this type of injury doesn't happen without negligence. So then the question isn't exactly what was actually going on in the anatomy of the plaintiff. The question is the expert's opinion about this kind of thing reliable?
Yes, Your Honor. And that's exactly where the abuse of discretion was by this circuit court. And I don't know if he didn't read the entirety of my client's deposition transcript or if he was misled. But let me explain. I'm glad you brought that up. So if you look at the entirety of Dr. Whitted's testimony, and I want to caution all of you that this was not a trial deposition. It was not even a normal deposition. It was a discovery-only deposition. And if you've ever done a malpractice case, a discovery-only deposition can only be used by the person that's taking that deposition for impeachment purposes only. This is not my time to drag everything out of my expert or have my expert explain everything because it's only used for discovery purposes and can only be used to impeach. This was not a trial deposition, but be that as it may. Page 25 of Dr. Whitted's testimony. He said, the defendant failed at lines 13 through 16, the defendant failed to exercise ordinary care while using the saw during the surgery, such that the patient suffered an extensive injury to the popliteal artery. That's not, and that's what the trial judge focused on. They kept arguing that my client was making some sort of strict liability argument. That's not what my expert was making. And I tried to explain that to him. I said, read the rest of the transcript. They took this one snippet and he took it out of context. And later, after he said that it was improper use of the saw that caused this injury and it was improper and it was negligent, at page 40, here's my client's testimony that the trial judge or the judge never took into consideration. He says, this is Dr. Witta's testimony on page 40, lines 22 through 24. So it was my observation that the plunging technique was more likely than not the cause of this injury to this degree. So we have specific testimony in my transcript, a discovery only deposition. And again, this is not a deposition where you pull everything out of your expert, because it's only used for impeachment purposes. But even in this discovery deposition, we have what we need. And the interesting thing when they
Do you
make this
think the
argument,
expert would say, if it turned out, if we were to magically learn that there was abnormal anatomy, do we think your expert's opinion would be the same? I'm trying to link the two.
So my expert, and I'll tell them right now, even though they didn't bother to ask him in his deposition, my expert will completely agree with their expert that absent anatomic abnormality, which is a question of fact, no question about it, and with proper retraction of the artery, you can't get into this popliteal artery unless you commit malpractice using the plunging technique. That's what my expert will say, and I'm telling you that right now, even though they don't even know that. So after the court, in my opinion, my humble opinion, abused his discretion in failing to look at the entirety of that deposition testimony where I pointed out what my expert actually said, I filed an affidavit. And my affidavit wasn't contradictory to what my client's opinions were or what he said. It explained it. It clarified it. And the case law is clear that that's something that is encouraged, so that we're not depriving someone who's had a catastrophic injury from having her case heard by a jury.
Is this the affidavit you
Yes.
filed on reconsideration?
Yes.
Okay.
And in my affidavit, that's what my doctor says. He said, when I said this doesn't happen without negligence, what I meant was, in the absence of a abnormal anatomy and with proper retraction, and when a surgeon employs the plunging technique, that's malpractice. And I have their client, Dr. Harper, admitting at page 82 of his deposition that he employed the plunging technique. Now, I submit to you that if I took this case to trial, and this is the kicker.
Well, I don't think he was that clear. I don't think he said, I don't think during his, and I read it, during his deposition, I used it. I think he's saying, well, it's sort of both, is
Yes.
what he said.
It's a hybrid approach.
It's a hybrid approach.
But-
You have to do both.
Yes, and he employed both. That's my point.
But I think it's a stretch to say I did the plunging, the very same plunging technique that you're claiming to be negligent as causing the injury. He didn't say it that clearly at all. He said he employed both approaches because you have to.
Yes, Your Honor, he said he employed both, including the plunging technique. My expert says you don't ever employ the plunging technique. And I want to read the testimony of their expert. Okay? This is their expert's testimony. This is my question, and bear with me, because this is important. Her case has been summarily dismissed. This is important. Listen, this is their deposit. This is their expert. I said, so I think I'm understanding what you're saying here, doctor. I want to clarify for my own sake is that without abnormal anatomy of the artery and with proper employment of their retractors, the most likely way that a popliteal artery could get injured by the saw under that circumstance would be improper use of the saw. Correct. And that would be improper. Well, he said, correct. If you were to have plunged with the saw, potentially that could have caused it, and that would be improper. That would be improper technique. Yes. No one ever. We do not aim to plunge the saw into the back of the knee. That's their expert. And I submit to you respectfully, and I'm trying to calm down here, is that if I had this case in front of a jury, I could get it to a jury based upon the testimony of their own expert, because I have everything I need from their expert. And the only thing I'd have to prove is that it's more likely than not that there was no abnormal anatomy to the popliteal artery, and that's a question of fact. Now, I want to comment on the defendant's briefing. It says at page 3, Dr. Whitted did not suggest that Dr. Harper misplaced the retractors. That's true. Misused the saw. That's not true. That's not true. And that's what the trial judge got hooked up on. That this was some sort of, I'm making some sort of strict liability claim. That's not true. This is not true. So, Your Honor, I'm going to sit down. I probably have occupied too much time, and I've probably been too emotional about this, and I apologize if I've gotten out of, in any way, been disrespectful to this court, because I consider it a privilege to be here for my client. But this court, the circuit court, abused his discretion in two specific ways. He did not consider the full extent of the discovery-only deposition that my client gave. And, in my opinion, he abused his discretion in refusing to accept my affidavit. And my affidavit was simply a clarification, not a contradiction. So those two specific areas of abuse have resulted in my client's case being summarily dismissed and depriving her of an opportunity to present her case to a jury. Thank you.
Okay, thank you. Any questions? No? All right. Mr. Anderson? Can we start with understanding that the most likely source of the injury to the artery was the saw?
Yes.
Okay.
So regardless of that, I know I want to speak to the affidavit first after solidifying. The opinion here, or the issue here, is Dr. Whittett's opinion, the reliability of his opinion. His opinion during his deposition was that this injury could not happen absent negligence. So we challenged that opinion. We filed numerous articles of literature saying there's many other reasons. There's, if you're obese, there's risk factors that can happen. It's a known complication. If you have aberrant anatomy or unusual anatomy, there's no real way to prevent this type of injury. It happens some percentage of the time, albeit small. So the issue is we're combating the notion that this injury cannot happen without negligence. During the, and again, there were 3 claims total in the complaint. There was a retractor claim, improper placement of the retractors. There was another claim about recognizing the injury, and those were withdrawn by plaintiff later. So this is after the trial court granted summary disposition. So this is narrowed down to the saw claim. And during his deposition, I'm reading from pages 40, 40 and 41. I said, so you concluded that Dr. Harper used a plunging cut with the saw based on the fact Ms. Kirk sustained a popliteal artery injury. Is that a fair characterization? He answered, correct. So his opinion that Dr. Harper used this plunging technique is solely based on the fact there was an injury that occurred. There's no, the deposition testimony that counsel cited, I asked specifically Dr. Whitted about that and said, did you read Dr. Harper's deposition? He said, yes. I said, was there anything in the deposition or in the medical records that suggests Dr. Harper's technique was improper or how he specifically inappropriately used the saw? And Dr. Whitted said, no, not any information from his deposition. So that is the reason. And in fact, I said, what about the records? Was there any information from the records? No, only the occurrence of the injury and the description by the vascular surgeon of the severity of the damage to the artery.
So in other words, in the surgery room, he didn't testify he used it. No one in the surgery room, in the surgical room, indicated he used it. The surgeon who followed to fix the severed or injured artery didn't indicate in, I think it was
Dr.
I think it was her, right?
Yep.
In her report that she saw evidence of that. So the only evidence, I use that term, evidence of it is the injury itself. This injury occurred, therefore this method of cutting must have been employed. Right? I mean, that's how this case sort of began.
That is the theory, yes, Your Honor.
Then we have the Dalbert hearing, and it sort of it moves a little bit from that position to something else. Would you agree with that, or am I mischaracterizing it?
I think it's a bit of a mischaracterization from the standpoint of really what we're attacking here is the idea that Dr. Whitted said this injury can't happen absent negligence. In other words, 100% of these types of injuries and total knee replacements are the result of negligence. Obviously, that's not true. And Frank,
what if we reinterpret that to mean more likely than not, when this injury occurs, it's because of negligence? Because that's the ultimate legal standard, right?
Sure. And again, there's a consideration of this aberrant anatomy and the obesity factor, which we agree that the patient did have that risk factor. And there's some kind of question about the panel here, and counsel suggested that there was a question of fact as to the aberrant anatomy. But as we stated in our brief, Dr. Kozovic, the vascular surgeon, her report the day following the surgery indicated that her dissection took longer than usual due to obesity and more lateral placement of musculature and neurovascular bundle. And she had very difficult time even finding the popliteal artery. So that suggests that there is some level of a unusual anatomy at play.
It suggests it. I agree.
Sure.
It suggests it. Is it enough? I mean, is what you're saying that it suggests it so strongly that what? How does that connect to reliability? I mean, if it's a question of fact, whether she had the abnormal anatomy or not, and we have some evidence that she had it, but we don't know for sure. What do we do about the question of reliability, which seems to be like a little bit different from that issue?
Sure. And I think it relates to the question of reliability because these medical records were available, obviously, at the outset of the case. Dr. Harper's deposition was taken before Dr. Whitted's deposition. And I attempted to ask Dr. Whitted all of his basis for this opinion that the saw was used negligently. And he said, simply because the injury occurred. So he doesn't address any of that, any of the evidence of aberrant anatomy. He doesn't address any of the literature. In fact, he says the literature is irrelevant and does not establish.
That was my question. In terms of the reliability question, he was asked the question whether there are any studies to support his conclusion that about the plunging technique. And he said there is no literature. And it would be essentially absurd to think that there would be. So we're back to the position. It is because I say it is. It is negligence. The plunging technique must have been used because I say it must have been used. That's what I'm struggling with. That there's no, in terms of the reliability, certainly he's an expert. There's no question about that. He's certainly qualified. But when an expert, a qualified expert opines on a subject where there's no literature to support the position, that's a red flag. It's not determinative, but it's a red flag. And then you have to ask, well, what is there to support it? And he's saying, well, my experience, it's obvious.
Right. And again, the Idri and Elher cases, which are controlling of this, establish that the experience and background is insufficient to establish reliability generally, especially as an Elher in the face of contradictory literature showing it can happen in the absence of negligence. It's a known risk. And in fact, defense expert Dr. Karadshe testified the same thing. He said it's a known risk.
You'd agree that there's some things that you don't need. Some things are so obvious in terms of medical malpractice or breaches of standard of care. You don't need that's reliability. For example, if she went in for, if a patient went in for a knee replacement on the right knee, but they gave a knee replacement on the left knee, I don't think you need an expert to explain that that's a breach of the standard of care.
Certainly.
I mean, that is self-evident.
Sure.
Well, we're in the world of a knee replacement. This is exactly the kind of area that expert testimony is needed and required.
Yes.
The question is in terms of the reliability.
Correct. Yes, it's needed and required, and it is the issue here is reliability. And again, it's like I said, the issue here is that there's no evidence that Dr. Whitted cites, nor is there any literature, nor is there any other information submitted by plaintiff suggesting his opinion that the injury indicates negligence is reliable.
I mean, let's put aside the abnormal anatomy situation, which I understand is a big issue. But putting that aside, don't you have some? I mean, if the experts on both sides agree that you shouldn't, that if you plunge through the tibia with your saw and slice open the artery, that's improper. I mean, that's like, you don't need I don't think you need a journal article to confirm that when both sides agree with it. It's just that here we also have this add-on of like, well, was there abnormal anatomy? Because then maybe maybe it wasn't the plunging technique that caused the problem.
Right. If I understand your question, Your Honor,
If we were to wake up tomorrow and discover that in fact the plaintiff did not have abnormal anatomy, doesn't the plaintiff's expert become reliable at that point?
Questionably, from the standpoint of I would say there's still the obesity risk factor, which is we all agree happens. And then the literature says that it's impossible to protect against this type of injury when you have unusual anatomy or barren anatomy, but it also says this is a known complication or a known risk of this surgery. So it doesn't say every single time this happens, if there's not a barren anatomy, this is negligent. It depends on, the factors and what the doctor did. And in fact, earlier this year, we couldn't cite it in our briefing because it came out more recently. There's an unpublished opinion in Walsh v. Sakwa. That's case number 356517 from July of this year. And it's a very similar case where the issue was a patient underwent a mitral valve repair and a catheter was stitched into the atrium. And the court concluded, and the plaintiff's expert's opinion was that should just never happen. There should never be a catheter stitched into the atrium. And the court concluded, that opinion is insufficient to establish the standard of care because it simply describes a bad outcome. It should explain what a reasonably prudent doctor would do. And so essentially what we're getting at here is he's saying he must have utilized the plunging technique because this injury happened, where we have Dr. Kosovek, the vascular surgeon. Her report indicates the anatomy was at least somewhat different because she couldn't find the popliteal artery, and she's a vascular surgeon, and she describes the anatomy differentiation. She said more lateral placement of the neurovascular bundle and the heads of the gastroc, which are the bones that guide her to the popliteal artery. So there was a barren anatomy according to Dr. Kosovek's operative report. And then we also have the fact that, not all incidents of this type of injury are the result of negligence. And in fact, I know by percentage, Dr. Whitted testified that because the percentage is very low in the reported literature of this injury occurring, that negligence, all of these injuries must be the result of negligence. And in fact, as we point out in our brief, this is maybe the most commonly performed surgery on planet Earth. So it does happen from time to time. And it's a known risk of the surgery. And there's nothing that Dr. Whitt had pointed to other than his experience and background.
But to Judge Crofton's point, assuming there are no issues with the anatomy, your expert even says it's highly, highly, highly unlikely that this type of injury would occur if proper technique was used. Wasn't that the testimony?
He said it's highly unlikely, but he also said that orthopedic surgeons perform tens of thousands of these, and at some point it does happen based on the wrong patient, wrong anatomy, et cetera. So yes, it is highly unlikely, but that doesn't necessarily mean that it is the result of negligence or he did something improper to cause the injury. And really, we're just getting to the basis of the opinion, whether it's reliable. It's asking to make assumptions and speculate about, the cause of this injury, when in fact, there are many other explanations. In fact, in the record, we have Dr. Kosovek's report, and we have multiple articles of medical literature that establish this is a known complication of the surgery, and it can and does occur without negligence.
What about the contention that the doctor didn't properly, I guess his notes weren't clear. He didn't properly put all the information within his notes. What about that contention? I mean, had he properly documented everything, would all of this have been questions that we're trying to get through later?
I don't think that's necessarily, perhaps, Your Honor, the second part of your question, I would say perhaps that would add clarification. However, Dr. Whitted himself admitted that placement of the retractors or the specific saw technique would not normally be found in a orthopedic surgeon's operative note. Like Dr. Whitted, plaintiff's expert, admitted that there was no issue with the operative note as far as what content was in it. It would be fairly impractical for an orthopedic surgeon to describe the exact placement and saw technique for every single orthopedic procedure. And as Dr. Whitted said, that's not common. That's not the common practice for orthopedic surgeons.
How about if there's an issue, like there was an issue in this case? Would it make more sense when there's actually an issue with the surgery to provide more details?
When it may make more sense, Your Honor, from that standpoint. I understand what you're saying now. However, again, he emergently called Dr. Kosovic into the room because as soon as he removed the tourniquet, he noticed the bleeding and wanted to address it right away. She took over from that standpoint. He was no longer involved. He possibly could have added more to his note about, what technique he used, but I think he was more concerned with making sure the patient was stabilized instead of, going back and trying to retrace every aspect of the surgery in his head. So perhaps he could have added more to his note, but again, Dr. Whitted indicated that there was no issue with the note, and there's never been a claim as to the documentation. So the other point I would like to raise, Your Honors, is the whole affidavit situation. As you know, the trial court had supplemental briefing after the initial our initial motion at the hearing. There was a motion for reconsideration in which plaintiff attached 2 affidavits of Dr. Whitted, and the second affidavit cited numerous excerpts from Dr. Harper's deposition transcript, and the point that we made as far as it being contradictory and why it should not be considered is the fact that during his deposition, he said, "I reviewed the deposition. Nothing in the deposition supports my belief that he used the saw negligently." And in fact, I read the quote earlier that he expressly denied that. So then coming back with an affidavit and saying, "Here's what supports my opinion that the saw was used negligently," is a contradictory affidavit that is not allowed, as we discussed in our brief. And again, there was 3 rounds of briefing before this appeal, or before this appeal came, and the court carefully considered the depositions of Dr. Whitted, our expert, Dr. Karadsheh, considered the filings on the motion for reconsideration, and frankly, on the record, we do not feel that there's an abuse of discretion. So we ask the court to affirm, and if there are no further questions. Thank you.
Rebuttal?
On behalf of Mrs. Kirk, I'd like to thank you for your time. I do want to point out a couple of things with respect to what was just argued. Again, at page 25 of Dr. Whitted's testimony, he said that the defendant failed to exercise ordinary care while using the saw during the surgery. I mean, it's in his transcript. And the other thing that I want to point out is that, I've tried cases for 25 years, and the courts do not require that you find a piece of literature that directly supports a claim an expert is making. It's never required. The way it works in trial is that lawyers will try to get articles admitted for impeachment purposes only. There's never a requirement you have to have an article somewhere that supports what you're saying. And I can't imagine a better source of reliability as you look at this case when you go back into your chambers and evaluate this case. There's 2 experts in this case, both board certified orthopedic surgeons, both highly educated and respected throughout the country. In fact, Dr. Whitted is one of the best orthopedic surgeons in this country. He's been qualified to serve as an expert in numerous courts. But the expert that they have endorsed and have submitted to be reliable, to be authentic, to be qualified, says exactly what my expert says. How more reliable can you get? And I'm telling you that if you read the transcripts carefully, if I'm permitted to try this case for my client in front of a jury, the only question that remains on the table based upon the testimony of that expert and my expert is whether there was abnormal anatomy. And that is a question of fact. And one that you, on all due respect, cannot take from my client and allowing her to submit that to a jury. Thank you very much.
Any questions? Nope. All right. Thank you very much. That matter is submitted. Turning now to item number 9, Mills Siding and Roofing LLC versus Margie Rosaro. Item number 372914. We've got Mr. Khan remote.
Good morning, Jacob Kahn appearing on behalf of Mills Siding and Roofing.
Morning. All right, go right ahead.
This appeal concerns the narrow question of statutory interpretation, whether the Michigan Home Sale Solicitation Act applies to a roofing contract that was not executed during the initial solicitation visit, but rather at a later date after the homeowners had independently contacted Mills and asked them to return and to proceed with the roof replacement. Initially, Mills had offered the Rosarios a free roof inspection after many of the roofs in their neighborhood had been damaged in a severe storm in June of 2020. After the inspection, the Rosarios consulted with their carrier, confirmed coverage, and only then proactively asked Mills to return to their house to move forward and finalize the contract. After several visits to the Rosarios residence, a contract was signed on May 13th, 2021. It's undisputed that the Rosarios proactively initiated the May 13th meeting. The district court correctly held that the act does not apply because the agreement was not there given as required by the act. However, on appeal, the circuit court reversed it based on an overbroad reading of the statute in an inopposite out-of-state case. Based on the statutory text, Michigan precedent, and the legislative intent, which all compel a narrower reading, the circuit court's order should be reversed and the district court's judgment in favor of Mills should be reinstated. At the conclusion of Mills' presentation of evidence at the district court trial, the Rosarios moved for a directed verdict. The Rosarios argued that the act governed the underlying agreement and mandated the inclusion of the statutory cancellation notice. In response, the district court expressed its doubt and difficulty in seeing how the act applied because the contract was not even contemplated until there was a subsequent inspection with the insurance adjuster. And then a transaction happened at the request of Rosario. The district court ultimately denied the motion and explained that the solicitation piece is a key in the analysis because no contract or binding agreement was formed during the initial solicitation visit, and emphasized that the second meeting at which the agreement was finalized was explicitly initiated by Rosario after independently securing insurance approval. Following the entry of a final judgment in favor of Mills, Rosario appealed to the circuit court. Contrary to the district court's conclusion, the circuit court found that the underlying transaction is subject to the act and that the written agreement should have included the statutory language and the right to cancel. This court should reverse the circuit court's ruling and reinstate the trial court's decision because the transaction at issue does not fall within the scope of the act. The act's statutory definition of a home solicitation sale limits the act's application to cases where the buyer's agreement is there given. That is, given at the time and the place of the solicitation. Because the contract was not there given at the time of the solicitation by Mills, the act does not apply.
Mr. Khan, can I interrupt you?
Yes.
The word there usually refers to a place rather than a time. So, so I guess I'm a little bit stuck on this notion that they're given literally means at the time and place.
Well, I think if you look at the language of the act itself with it's the solicitation of the sale received by the buyer at the residence and the buyer's agreement or offer is there given. It's all part of the one pitch to get them to enter into the contract. It has to be a contemporaneous involvement. I think the and is conjunctive, which welds the clauses together. And I think that's what the Patrick course held, that, you know, it had to be there given at the time of the sales solicitation.
Well, the contract was presented to Ms. Rosario. Is that right?
There was a discussion about the roof replacement. The way Mills works is the actual contract is not signed until after the insurance approves the scope, creates what's called an exactament, and then the actual contract is signed at that time.
Right. So and I'm sorry, I'm forgetting his name, but the individual who worked for Mills Siding and Roofing comes out to the house after the insurance has been approved, and he has a contract with him. And he says to Ms. Rosario, here, if you'd like to have your roof replaced, sign here. And this happens at the house. So it happened, it was there given, seems to me. And the signature is placed on the contract at the same time that your client's representative went out to the house with the contract in hand.
But I think that the key part that you're respectfully missing is if the homeowner requests you to come out, it doesn't fall under the Home Sale Solicitation Act at all. It's if the contractor themselves initiates the solicitation through a door knocker or the solicitation by telephone or by coming to your house. So in that case, what we're arguing is it breaks the causal chain. That, you know, if the initial visit where Zach had came out to the house, met with Ms. Rosario, she had signed the contract, we'd be having a different discussion. But because at that initial meeting, she seemed weary on whether there was actually the hail damage on her house. She wanted to call the insurance company. An adjuster came out, confirmed damage and the scope of what the replacement would be. And only after that took place, she called them back. The argument is the contract wasn't there given with our solicitation. She had initiated the follow-up meeting, and that's why it falls outside the scope of the act. I mean, if you look at the statute that the circuit court relied on from Pennsylvania, it's a much broader statute that anything that
I agree with you that I don't think we need to focus on Pennsylvania. I agree with you. But I don't, no, that's fine. I don't see in the text of the statute anything about how if the customer initiates, that takes it outside the scope of the act. So I think what you're relying on are these two decisions, Patrick and Brown. And it just seems to me that Brown and Patrick are quite different in the sense that in those cases, there was never any home solicitation to initiate the relationship, that the customers in those cases initiated the relationship with the sellers. And here it's clear that you did have a door knocker. It's just that the contract wasn't signed at the very moment that the door knocker came to the house.
It wasn't signed when there was an initial door knocker. The door knocker and Miss Rosario, after he had told her there was hail damage, that's what provoked the Zach Diamante to come out. That was the initial meeting where they actually talked about the roof replacement. After that was the intervening event of the insurance adjuster and then her request to come back. So it was no longer Mills initially initiating that solicitation. It was her inviting them back saying she wanted to proceed. She was in control of the contract at that point in the request for Mills to actually do the work. She hadn't signed any agreement with Mills at that point. After the insurance company confirmed the damage, she was free to call anyone and have them come back. We weren't actively looking out to perform her work. She reached out and initiated the contact. That's why the argument is that it wasn't there given.
Really? Your client wasn't looking to do the work that
There was no,
Rosario's initiated the contract? That doesn't, I mean, I get the break in time, but it does seem like if you're sending a door knocker, you know, it's at some level, you're trying to, you know, get the business, right?
well, I understand that, but the record wasn't, you know, there were several follow-ups by Zach Diamante following up on her, what the status was with Progressive and the actual insurance claim and whether it had been approved. There was the meeting that took place, weeks passed by. She called them and said, I've confirmed there's damage. I'd like to proceed. She had initiated that follow-up meeting. And I think if you just look at the act in its general, it's to protect the vulnerable customers that are caught off guard from the in-home sales pitch and then pressured into an immediate decision. That's not what took place here. You look at the act itself, there's exceptions for emergency services. You know, if after there's some sort of storm, if I came out and your basement's flooded and I offer those services, it doesn't need to have the cancellation notice. That services I'm rendering on the spot. The point of the 3-day cooling off period is if you were part of some high pressure pitch or high stakes one sitting sales deal, you're entitled to just 3 days, 3 business days to decide if you want to proceed with the work. But that's not what took place here. There was weeks of lapse in between. And then she's the one who initiated Mills returning to the house. And after she had gotten the scope approved by Progressive, a contract was formed at that time.
There's no indication that she saw the contract before he came to the house, right?
So the way Mills operates is at that first meeting, had she wanted to proceed with Mills on the spot, there would have been a blank contingent agreement signed with language that it was contingent on a carrier approval. And then once the carrier approves it, there's a subsequent meeting because you then have the insurance estimate that says what they'll pay for the work. You sit back down with the homeowner. At that time, you pick the color shingles they want. You use the insurance number of what the cost of the work will be, and then you sign a subsequent contract. So every file that Mills has 2 contracts. The initial contingent one, once it's approved, they sign a subsequent one with the exact amount the insurance is going to pay for it, and then the homeowner picks the shingles from the shingle board, and then they proceed with scheduling the work.
I had just a practical question about how the statute plays out, or at least would play out in this case. Assume that you are unsuccessful on appeal. The homeowners in this case have, as I understand it, a new roof, correct?
So they had the roof that we performed. Part of the issue of why they negotiated a discount is it was installed later in the year. If it's not the right temperature, the underlayment doesn't adhere right. So there was what's called mole runs, little bubbles. But the testimony from Ms. Rosario is the roof functioned and kept the house dry. It just had a cosmetic issue. Okay. Then there was a shingle recall that just, what's the irony? And Mills had negotiated an entire roof replacement with a voucher for the material, a check for the labor, to allow Ms. Rosario to get an entirely new roof from Owens Corning.
Okay. Setting all that aside, she has, let's say that this is a different case. Okay. Let's say you're unsuccessful on the appeal and you have a homeowner who does a solicitation with the door knocker at the first initial contact. Okay. That's what we have.
All right.
Contract completed. That contract does not have the 3-day cooling off period requirement that the statute requires. Okay.
All right.
Work is done. Homeowner gets a brand new roof. Homeowner, because they've read an opinion, says, well, you know, the contract that I signed didn't have this 3-day cooling off period. Therefore, I'm not going to pay you anything for this roof. Follow me so far?
Yes, sir.
Okay. What I'm wondering is there this, as I read the statute, the homeowner can assert their rights at any time, correct? There is no, I'm sorry?
That is correct. And if you later provide them with the cancellation notice, the 3 days runs from when that notice is provided.
All right. So this could, this statutory right can be asserted at any time, even after the work is completed, refusing payment, even if the work had been done properly.
If it falls under the act, yes, Your Honor.
Okay.
It's similar to the Robert Stokes v. Millen roofing case. You know, a unlicensed roofer can properly perform the work, and then you raise the issue they weren't a licensed residential builder, and it's a very harsh remedy, but it's a complete bar to recovery. Yes.
Got it. Okay. Thank you.
Right. You know, in addition to, you know, what we briefed, I think it's important to look at the Senate bill that was introduced in June of 2025, because the proposed revisions of the act in Michigan, if it were to be passed and implemented, would remove their language from the act. The fact that there's a Senate bill proposing the revision to the plain language of the act confirms that Patrick correctly interpreted the text as currently written, and that the solicitation needed to be signed during their given pitch, as the court had found.
I don't know that we need to look at bills to construe statutes. I see your point, but I'm not sure that is helpful in terms of statutory interpretation.
Right.
A bill that is pending or didn't pass.
No, I understand. I just think that it makes us closer in line to the much broader language of what they have in Pennsylvania, which is what the circuit court had relied on. And then, you know, in response to the brief that was filed by the Rosarios, I think it's striking for what it doesn't say. They don't dispute the fact that the May meeting was initiated by Ms. Rosario, that, you know, that wasn't the initial solicitation pitch by Zach when he came to the house trying to engage her for the roofing job. And, you know, for those reasons, that's why we believe this falls outside of the scope of the act, and that the trial court's judgment should be reinstated.
I realize this case was in district court, but it did strike me as odd that this issue came up in the middle of trial in a motion for a directed verdict. That surprised me. It seems that I know this strikes me as an affirmative defense. It was something I think I identified as an affirmative defense in advance. So it's not as though the appellee here was hiding the ball in terms of waiting till trial to raise it. But do you have anything to say in terms of this being raised not in a pretrial motion, but instead as a motion for a directed verdict?
I can say that Mills was caught off guard that this was raised by a directed verdict, not by motion practice prior to the date of trial. Yes, Your Honor.
Again, I know it's district court and things are a little looser there, but the way that this came up and was decided in a motion for a directed verdict struck me as improper.
This case also started with the Rosarios as pro se defendants. Admittedly, in 8 years of practice, it's the first time I've had someone ask me to sue them. We placed it into litigation. I don't remember if it was 6-8 months of self-representation, and I'll give them credit. They used some sort of AI to draft affirmative defenses. But once Mills had made clear we were asking for a trial date, then an attorney appeared, a scheduling order was essentially reset. I won't dispute the fact that the Home Sale Solicitation Act was listed as an affirmative defense once counsel had appeared. But the actual motion was not raised until halfway through trial.
Okay, thank you.
Thank you.
Anything further?
No, Your Honor.
All right. You've got some time for rebuttal.
Thank you, Your Honors. Christopher Morris on behalf of the Rosarios. I think it's easier to talk about this case as Mills Roofing versus the Rosario family. I think you're correct in establishing. I was kind of flummoxed during trial when the plaintiff's witness referred to what happened as a door knocker. That was a new term for me, that they came to the Rosario residence, a door knocker knocked on the door and solicited the sale. So the Home Solicitation Act was raised as an affirmative defense. And I do want to point out to the court The problem with motion practice in district court is you don't do depositions, and you don't really have all of the facts developed in order to support a motion for summary disposition the way you would in circuit court. So these things are, this was a one-day trial. It's a consumer protection trial. It's procedurally, it's not really practical to proceed with depositions and interrogatories in a pretrial practice. It is very simple. Door knocker approaches the family who does not know that they have a problem. They have not seen a problem. They have not experienced a leak in their roof in 10 months. But the door knocker says, we can get you a free new roof. Go to your insurance company. Here's what you tell them. You'll get a new roof paid for by the insurance company. There is a break. There is some investigation by the homeowner, but there's no evidence that a contingent agreement was presented to the homeowner at the first visit. What was presented is at the conclusion of the transaction, an agreement was signed. And by the Mills representative's recollection, they signed it in the bed of his pickup truck in the driveway of the residence. Now, the interesting thing about this statute is it's very poorly construed by appellate courts, so I'm glad this case is here today. But the word there is a word of place, not a word of time. And the statute is very interesting that the legislature considered time factors. For example, they define business days. They define the amount of time, and they say the business days do not include Veterans Day, Thanksgiving, and so on. So the legislature had a clear intent to consider time when they were enacting the statute, but they did not include time as a factor in the definition of what a home solicitation was.
Do you think the Patrick or Brown case do that?
Well, I think they're distinguishable on a number of grounds, but they do not concern an agreement signed at the home.
No, in terms of time, do you think they put a temporal component to it?
I think that would be a overread of the statute. I think that the court does not have the ability to insert language into a statute.
You're carefully not answering my question. Do you think either those cases do that?
I do not.
Whether you agree with the cases and whether you think it puts a temporal aspect to it or not, you don't think there's any language in those cases that put a timing aspect?
I think that the facts of those cases are distinguishable, and that's what puts the timing at issue in those cases. It's not present in this case. It's not present by the facts here.
So let me give you two examples that I'd like to run by you. Both are a door knocker who leaves something on my, and we've all received these, on my handle, okay? One's from True Green Lawn Care. The other one is from Leaf Filter, to have a filter on my gutters. After receiving that notice on my door, I go in, I consider about it, I talk to my spouse and we talk about, yes, I think we need to change lawn care providers. Or, you know what, it is dangerous that I'm on this colonial house going on 2 different levels, cleaning out every year leaf that are in my gutters. So I call them and they come in and give me an assessment of my lawn, or give me an assessment of the cost, because they don't know the size of my colonial house and they have to make a determination. And we go back and forth a little bit because I have a unique weed I want to resolve in my lawn that seems to be stubbornly persisting. Or I have a colonial that Leaf Filter has a policy that we're going to put all filters on both levels. We're not just going to come here and put one level, but I'm a homeowner and I don't like getting onto the second level, but I'll do the first level because I think I can manage that. So there's some back and forth negotiation that I want one level of my house with leaf guards and I want this particular weed resolved that's stubbornly persisting. So we go back and forth over the course of days, weeks, maybe even a month or so. And finally, I sign on the dotted line, and it's probably digitized because they're all digitized now, that finally the manager comes down and I sign that document in my driveway after much deliberation and much thought. But that form that I sign doesn't have the 3-day cooling off period. Under your understanding and your reading of the statute, I would be entitled to obtain those services and not pay for them.
No, I disagree with that because
what's different?
I think there's a claim for quantum merit. What's important about this agreement is they abandoned the quantum merit claim and they proceeded against the homeowner. And then they said, we want our attorney fees paid under our agreement.
Well, let me back up. For setting aside whether I can get the service without paying for them. Under my scenario, both of those scenarios, you would argue that the contract that I signed is not enforceable. The contract is not enforceable because it does not have a 3-day cooling off period, correct?
That's correct.
Okay.
It's mandatory under Michigan law and it's mandatory under other states under Federal Trade Commission. It was a big deal in the 1970s to protect homeowners who were subject to abusive home solicitations. So it's a simple act to comply with.
Not much abusive in my two scenarios I gave you.
But it's an easy act for a company that is in the business of making home repair solicitations to comply with. It's not hard. It just has to be in 10 point. It has to say that. There's some very basic minimum thresholds that you have to inform consumers before that contract is enforceable. And it doesn't seem very onerous to me. The statute's been there since 1971. It's not brand new law.
So you were saying that you would distinguish, really, I think there's just two cases. It's Patrick and Brown. I mean, that's basically
Right.
what's out there. And you said you would distinguish those on the facts?
Yes, and the method of acceptance, et cetera, they're very distinct. They're very different fact patterns than this. One's involving gold and, some kind of precious metal. And I haven't reviewed those cases today, but they are not strictly applicable here. This is a pretty simple fact pattern. Approached at home, door knocker, signed in the driveway. It's not a complicated fact pattern.
If all of that happened at the same time, I think I'd agree with you.
But the statute doesn't say that. It just says they're given. And
I agree with you so far, and then we turn to the cases.
But the cases should not and cannot add statutory language that is not present in the legislative act.
Nevertheless, we have to follow published cases. These are published.
Well, I think those cases are not binding on what this court is going to do.
Oh, I think they are, but the question is whether they're distinguishable in a material way.
Correct. I agree with what that you've correctly stated that.
If we think that this case is on all fours with Brown or Patrick, then we go with what Brown and Patrick says. I think the question is whether it's on all fours with this case.
Correct. And, it comes down to the word there. We will meet over there. We will meet over there at noon. We will meet over there next week. There does not give a time factor. It is strictly related to a place. Any other questions?
I don't think so.
It's a lot more fun than your medical malpractice cases, I think. A lot easier to sort through the facts.
Stick
because
around.
They're simple.
The door will allow you to stay here as long as you like.
Well, I appreciate that. I've been here before and I know how that works. So thank you.
All right. Very good. All right. Mr. Khan, any rebuttal?
Yeah, briefly. I will note there was a pretrial order in the case with discovery that, we could have had depositions. I will admit that may have been issued before Mr. Morris appeared, but there was a scheduling order that allowed for discovery without the parties asking for it. Another point that I'd like to note and is attached to our brief itself, the insurance estimate that was prepared on behalf of Progressive was created on April 29th of 2021. The contract wasn't signed in this case until May 13th, 2021. So it was after the scope had already been determined, the price that would be paid for the work. It was Ms. Rosario had asked Mills to come out. Here's the estimate. This is what you would get. Will you do the roof? I mean, I think when you look at the definitions of the act and you read them together, it becomes clear that whether the solicitation occurs at the doorstep, over the phone, by a flyer, the act is only triggered if the buyer yields to that solicitation and commits to it on the spot. I don't think the legislature's intent was to police every contract for goods or services that began with some sort of solicitation. Rather, it was only regulating and giving consumers the special right when there is the immediate pressure to decide. And that's why there is the 3-day cooling off period. And I don't think the facts here come close to satisfying the statutory trigger. Because the agreement was not there given at the time and place of Mills' solicitation, the initial meeting between Zach D. and Ms. Rosario, I don't believe the later negotiations fit the act's narrow definition. And I think it's like the buyer in Patrick, because Ms. Rosario took several actions between the initial meeting that broke the link between the initial solicitation. She had called the insurance carrier, she had confirmed the damage, she got a scope of work, she got a price for the work, and then she took the affirmative action of asking Mills to come back. At that time, Mills was being solicited by her to do the work. It's, here's the insurance estimate, will you do my roof for this amount? Because
Well,
of the
I think the trial testimony is that, and I'm sorry, the name of your agent.
Zach Diamante.
Yeah. So Diamante says he comes to several of the, he comes to like the insurance inspector's visit, I think. And at the end of that, I think the testimony reflects that he says to Rosario, after you hear back and get approved from the insurance company, call me back. So I mean, she did call him, but I think it doesn't seem to me that like out of the blue, she just decided, hey, I'm going to go with Mills. There was a door knocker who came to the house, and there was a second guy who comes later and says, when you get the insurance approval, call me. And then she calls, and he comes out and he brings a contract, and they sign it right there and then at the house. That seems a lot different from Brown and Patrick to me. So it doesn't seem like we have a case that is presenting the exact facts that we have here.
I understand. I just think the causal break in the investigation she did, and the fact that instead of a contingent agreement that Mills will do it for whatever the insurance approves, it was only after she had secured the scope of work and the terms of what the contract would be, her affirmative actions to take control of this deal and this agreement are what make it fall outside of the act. Okay. It was no longer Mills soliciting her on that May 13th meeting. It was, here's what it will be. Is Mills going to do the work for the insurance estimate that I've already had prepared or not?
Okay, I think we've got it. Thank you very much. The matter is submitted. We're going to take a 10-minute break, and when we return, we're going to start with number 11 because item number 10 has been adjourned.
Your Honor, I can very briefly on my argument, it's on page 8 of my brief.
Okay, thank you.
Thank you, Your Honor.
Well, good afternoon. We are starting our 11 a.m. call right now, a little late. And just to recap, I think we have a few cases coming up involving minor children. If you have any children that are involved in your case, please do not identify them by name. And if you have any clients that are in the courtroom, if you could please just note that just so we know that your clients are here. And then finally, on this particular case, which is item number 11, Township of Bear Creek versus Cannabis Regulatory Agency, that's item number 369629. I need to identify something you probably both already know. I previously served on the Court of Claims. When I was on the Court of Claims, I resolved one issue involving one but not both of the parties. That case, I understand a different case was filed, so it's an entirely different file number. I identified that. I don't see that I have any conflict or need to disqualify myself, but I wanted to point out what I think, based on your both nodding, that you both already know. Do you have any, if you could, appellant, if you could please identify your name?
Good afternoon, Your Honor. That is Morgan on behalf of.
Any objection that I proceed, move on? All right. If you could identify yourself.
Kevin Blair on behalf of the Pelley Green Sunrise Product.
All right, terrific. Thank you both very much. And why don't we just get right to it? Why don't we start first with Appellant? Go right ahead.
Actually saves a lot of time procedurally, so we don't have to go through it because you lived it, as did I. Procedural matter to start with, I'll file a formal substitution of counsel, but as of yesterday, I'm a member of Clark Hill's Lansing office. So my old firm will not be involved in the case any further. So let me start by saying this case is about the license, not the lease. And that's where I think the trial court got it wrong by focusing on the federal regulation to say that the township can't interfere with a tribal lease on trust land. That's not the impetus of the complaint by the township. The township was a township that opted out pursuant to state law from recreational marijuana. And if you read the lease, which is included in the record, obviously, the tribe waived sovereign immunity, subjected its lessee to state regulation, and there you have it. So my point is simply this: how can you pick and choose what state laws you're subject to? Because I've driven by this location in Petoskey, and I see state police cars parked out in front of it doing something. I don't know what, but I don't know how you can subject yourself to state regulation and then all of a sudden act in a township that's opted out of recreational marijuana. So this isn't a tribal sovereignty issue at all. It's a matter of state law, state regulation, and state law is pretty clear. If a township opts out of recreational marijuana, you're not allowed to dispense it in the township, simply put. And again, how can you pick and choose? Does that abrogate the township's right? No, I submit not. What it means is that if the tribe is doing something separate and apart from sovereign immunity, which the lease clearly states, then the lessee, in this case, Loom, the defendant, is subject to state law. And state law says if a township opts out, recreational marijuana is not to be dispensed in the township. And that's simply our point. I'd like to quote, and I'm sorry, at the beginning, I should have said to reserve some time for rebuttal. I'd like to quote from the trial court's reconsideration opinion, which again is part of the record. And this is page 4 of the written opinion. Quote, "The court cannot say that Bear Creek is wrong," end quote. So my question is, okay, then why was summary disposition upheld in favor of Loom? Because, as Judge Cameron, we went through some procedural machinations here, starting the Court of Claims, which I thought was the right thing to do. And then the Court of Claims, in my opinion, rightly decided that because Loom was a necessary party, court didn't have jurisdiction. So I did what I think was the second best thing to do, or second right thing to do, which is go to the Emmett County Circuit Court. And the Emmett County Circuit Court, if you read the transcripts, basically said, okay, because the state stepped up and said, you have to sue us in the Court of Claims. And my point was, I tried to. And so the trial judge said, so the state's untouchable? And that's essentially what the state said. And my point is that there's a gap in the statutory scheme here that if you have a situation, and again, I want to make it clear, this is not a tribal sovereignty issue, even though it's on trust land. If you read the lease, they waived all sovereignty. So I went to the Emmett County Circuit Court, and the judge even said the state's untouchable. And Assistant AG said, yes, essentially we are, unless we're in the Court of Claims. Well, I couldn't go to the Court of Claims. So getting back to the reconsideration opinion, the court cannot say that Bear Creek is wrong. So my point is simply, okay, why are we here then? Why can't the township simply ask that the license be voided and rescinded? If the tribe wants to do something on its own, I think some recent legislation and case law suggests that they can do it that way. But in order to do that, you need a supplier. In order to get a supplier, you need a state license. In order to have a state license, you need to be regulated. So that's where the gap is. And that's what we're asking for. Court went on to say in its reconsideration opinion, the end result regarding Bear Creek's authority to enforce their ordinance is the same with or without a license. And my point is simply logistically, how would that work? Are you going to issue a civil infraction on a transactional basis, on a daily basis? I mean, the district court in Emmett County would be up in arms. You know, you're going to have 50 civil infractions every day for people that stop in there and buy recreational marijuana. So at the end of the day, I'm just suggesting that there's a gap that needs to be filled here. And this is unique in the sense with the lease, because the lease waives sovereign immunity. It subjects the lessee to state regulation. And that's why the license should be voidable, because it's in a township that opted out. If it's something different, if it's simply trust land, if it's simply the tribe doing something, that's another issue. But we're not dealing with that today. What we're dealing with is a lease that said you're subject to state regulation. So how can you pick and choose which state law applies? And my proposition is simply this. If a township opts out of recreational marijuana, then recreational marijuana should not be sold in that township. Any questions?
I don't think so. Thank you.
Thank you.
Plenty of time for rebuttal.
Good afternoon, Your Honors. Kevin Blair again on behalf of Appellee Green Sunrise Products that does business as Loom. I want to start by reiterating, I know the court has read our briefs. I want to just reiterate that this is the third bite at the apple. The Bear Creek Township started this with a request under the APA for a request for a declaratory ruling. They did not like the response from the CRA on that. I believe it was called the MRA at the time, but that name change means nothing for substantive reasons. But in any event, the Bear Creek didn't like that response. The APA provides for an appeal procedure for judicial review of that. Bear Creek did not pursue that route. Bear Creek then sued the CRA in the Court of Claims, and Loom moved to intervene because Bear Creek was essentially trying to invalidate Loom's license. And under the existing law, the court did not have jurisdiction over an intervening defendant. And that case was ultimately dismissed. Bear Creek did initiate an appeal of that issue and then dismissed it voluntarily without ever explaining that. And I thought that was one thing that council might address today because that's still a key unanswered question here. Then the third bite of the apple was suing the CRA and Loom in Emmett County. And the CRA moved for summary disposition because there's no jurisdiction there, of course. And then the court ultimately granted summary disposition there as well. I thought it was also interesting, council didn't even address the mootness argument, which I think renders this case moot. The legislature has, as we detail in our briefs, legislature has enacted amendments via a supermajority because this was a voter initiated statute that clarify and confirm that the legislature understands that voters intended that the voters never intended to discriminate against Native Americans. And Bear Creek goes to great lengths to try to connect dots of, oh, well, this says you have to send an application to the municipality. Well, that means voters must have intended to exclude Native Americans from this market. There are tribal trust lands throughout the state that have all sorts of commercial properties on them, Starbucks and nail salons and et cetera. And the CRA allowed a license on tribal land here because there is no statutory text in MRTMA that anyone can reasonably infer a voter intent to discriminate against tribes. And even if they did, that would raise all sorts of other constitutional issues. And we address in our briefs why courts don't go out of their way to interpret laws in ways that would raise other constitutional issues. The legislature changes in 2023 clearly contemplate that there would be a retailer on tribal land. That is in MCL 333.27963 sub 1. That's retailer is an establishment such as Loom Store, collects the excise tax. And then MCL 333.279.64.5, and I want to read that one if I could. It's 279.64 sub 5. Quote, if a marijuana retailer or marijuana microbusiness is located in Indian lands, the portions of the unexpended balances attributable to the marijuana retailer or marijuana microbusiness that would have otherwise been allocated to a municipality under subsection 4A and a county under subsection 4B must instead be allocated to the Indian tribe in whose Indian lands the marijuana retailer or marijuana business is located. We explain in our brief that only makes sense with our interpretation, the plain language reading that these retailers can exist on tribal land.
Sorry, why does that make it moot? That might make it moot going forward, but in this case, if the property was being improperly used at the time before the MRTMA amendment was enacted, aren't there potential repercussions in terms of fines or whatever for that?
Your Honor, I have two responses to that. One is that the complaint only sought prospective relief, injunctive relief. So there was no claim that was pled for any sort of monetary relief or anything from past conduct.
Do you happen to remember if it sought a declaratory judgment?
Off the top of my head, I do not recall that, Your Honor. But the second point I was going to make, Your Honor, is that goes to the standing point of the township saying that because this tribal land is surrounded by township land, voters intended to infringe on sovereign immunity of the tribe. And that is absurd for all the reasons we've outlined in our brief. But it really would be the same as if the court were to adopt that novel interpretation of MRTMA, that would mean that municipalities could challenge the validity of a license in a nearby municipality. And we don't want the multitude of suits that will come up that way. If you have some communities that wish that their neighbors had less stores or no stores, and they want to pick apart, did they file this form on time, or did they really meet this standard? Or, there's no instance that a court has recognized standing of one municipality to challenge a license that's in a different municipality. I think the best that council came up with in the reply brief was the Rockenbach case that concerned a dispute between two landowners within the same municipality. And the question was whether the municipality needed to be a necessary party. And I think that analogy breaks down in the sense that those were peer landowners under the same governing structure of law. And the court reasoned that because nuisance would still be a possibility of recovery there, the municipality didn't need to be a party, because whether the municipality allowed this land use or not was irrelevant as to the nuisance claim. So they weren't strictly a necessary party. But that's different from the situation here, where there's zero dispute that the tribe land is sovereign and is not part of Bear Creek's jurisdiction whatsoever. And Bear Creek's January 20, I think it was January 6, 2020 letter admits that. That was one of the earlier communications between the parties. Bear Creek reaches out to the tribe and says, we know that you have sovereign immunity and you have absolute control over what you're doing with your land there, but we'd like you to not allow marijuana stores because we don't like them and we don't want them near our areas as well. So I think that's where this breaks down in terms of the standing of whether Bear Creek can even dispute what's happening on tribal land. I think that's the quote that council read out of context was, it doesn't turn on whether there's a license or not. The tribe could be growing and selling their own marijuana on that land. They could be leasing it to a state licensee that's doing it under a state licensing regime. There's no way that Bear Creek can say that sovereign tribal land within its borders can be used one way or another. And the limited sovereign waiver in the lease and in the agreement with the CRA is that the CRA can come in and do their inspections, right? That's the other, Bear Creek's kind of talking out of both sides of their mouth, because then they say, oh, this means that this land is completely immune and nobody can ever regulate what happens there. That's not true, in that Loom has the license, and that license can be turned off at any moment and revoked if Loom did anything that there were health and safety concerns. Loom is also, as Bear Creek mentions, Loom is getting all of the materials and the products for that store from other licensees in the state. And so the CRA could effectively stop any new product from coming onto that property. The absolute worst case scenario, if the tribe went completely rogue and said, no, we're not allowing any CRA personnel on our property, would be that they could cut off Loom's license, so they could no longer sell in compliance with state law. And Loom has other licenses, so they have more incentive than even just that license to listen to anything the CRA is saying. And then, absolute worst case scenario is whatever product is in that store might be, stuck in that store, and the CRA can't get in there. But again, we're talking about products that were licensed and tested and, completely safe. We're not talking about illicit product that would be stuck on land that the CRA couldn't get to. So anyway, that's the worst case scenario, but the Bear Creek presents that as, oh, you must find that they have a right to challenge the validity of license that's outside of their jurisdiction, because otherwise the sky would fall and there would be health and safety issues. That's just not true. So we talked about the statutory amendments clearly contemplate that there would be a retailer on tribal land. There was a red herring in the reply brief about those same statutory amendments in 23 also allow for these agreements with the tribes, where
by which the tribes actually participate in the market, meaning that they either grow it or process it or sell it, and they can interact and exchange these goods, these licensed goods, with other licensees. That's a completely separate scenario. It was part of the same amendments, but the language specifically in 279-64 sub 5 that I had read makes sense in no scenario other than a retailer being on tribal land, and a tribal marijuana business is not a retailer. We pointed that out in the brief. The tribal businesses under MCL 333-27953 BBII are not establishments, and they collect like a parity tax or fee, but that's not state money. That's the MCL 333-279-53 IIA specifies that the money that the tribal businesses collect is not the excise tax money. It does not go into the state fund. And so when it says that the money that would otherwise go to a municipality is going to the tribe on whose Indian lands the retail store exists, that only makes sense in this scenario. So the legislature has clearly authorized this and confirmed that that was always the voters' intent. The township has argued it on page 2 of the brief that the central issue here is whether MRTMA allows allows licensed retailers on tribal land. Again, especially with the 2023 amendments, we think that that's absolutely clear. We've talked about the standing a bit. The township is trying to challenge the validity of a license in a different municipality, and on top of that, they're trying to do that in a case where the agency isn't even a party. They say that they're not trying to enforce their township ordinance on tribal land, but in their reply brief on pages 6 and 8, they acknowledge that retailers can be on tribal land under the 23 amendments, but they say that they still have a supposed substantial interest here because the township surrounds the tribal land.
Is there anything you want to note that's not in the briefing?
Yes, Your Honor. I would say that their argument that they do have this substantial interest because the tribal land is within their boundaries under their interpretation. This didn't occur to me until I was preparing for this today, so it was not in the briefs. But another reason that is wrong is that they've cherry-picked statutory language and oversimplified things. Their argument is because they surround the tribal land, they can prohibit marijuana retailers anywhere within that perimeter, even if it's on sovereign land within that perimeter. But that same language that gives them the right to prohibit stores, that they believe gives them the right to prohibit, also says that they can limit the number of stores. So let's say tomorrow there's a political change in Bear Creek Township and they decide they want 2 stores, not 0 stores. So then what do? Then Bear Creek gets to decide whether the sovereign tribal land gets either of those 2 or both of those 2 or 0 of those 2. It's the same statutory language that says it can prohibit. And if we go down the path that you can prohibit on sovereign land within your boundaries, the next iteration of this interpretation is going to be, okay, well, what about the municipalities that surround tribal land and impose a limit? How do you count the tribal land stores there? Just want to skim my notes real quick, Your Honor.
You just got a couple more minutes.
I think that's all I had. If the court doesn't have any other questions, thank you very much.
No, I don't. Thank you. Thank you.
Thank you.
Rebuttal?
as it relates to the first appeal that was banded, it was my decision because I thought the Court of Claims got it right, that there was a non-governmental entity that was a necessary party. And that gets back to the trial court's statement. So the state is untouchable because tried to sue them in the Court of Claims, got dismissed, tried to sue them in Emmett County, they got dismissed. And that's the gap we're trying to close here, part of it. Anyway, I would suggest the case is not moot because this case is unique. It's pursuant to a lease where tribal sovereignty has been waived. And my last check of the CRA website was that the tribe is not receiving any tax revenue from recreational marijuana sales in Bear Creek Township. And bear in mind, the trial court denied the precise basis upon which it granted summary disposition in March of 23 and then granted it in October 23 sua sponte without a motion of reconsideration or anything else. I don't know why that happened, which is why we're here today. I think the statutory amendments are a red herring. Our claims have been pending for quite a while, and I think they would be retroactive regardless of whether or not there's a regime change at Bear Creek Township. And my last point, again, and I don't mean to make this ad nauseum, but if you subject yourself to state regulation, how can you pick and choose what state statute or what state regulation you're subject to? And that's precisely what happened in this instance, which is, yeah, we're going to subject ourselves to the MRA, now known as CRA, but we're not going to abide by the statute that says the township can opt out of recreational marijuana sales, which is what Bear Creek Township did. Thank you.
Okay, thank you very much. The matter is submitted. Turning now to item number 12, Hoker versus Arba International LLC, item number 374540.
Good afternoon, Matthew Swartz on behalf of the appellant, Timothy Hoker. Your Honors, really what this boils down to is whether and to what extent the defendant appellee here exercised reasonable care once this electronic bike was put into the marketplace. That issue is dependent on several sub-issues, which I will certainly address. Ultimately here, our contention is after the defendant learns of the multiple complaints about the front forks of this electronic bicycle, it should have done something. Reasonable care requires some sort of action. They did nothing. Because they did nothing, my client did not realize that this was an issue. Ultimately, that led to his injury. I can go through the timeline here. The incident occurred August 2nd of 2020. Mr. Hoker purchased the bike in April of 2020. Subsequent to that, in May and June, many complaints came in, approximately 7 in a 2-month period, complaining about specifically the front forks being bent. All of the complaints were specific to that issue. June 17th, the defendant decides to replace all of the front forks for every bike, not the bikes that were damaged, not for the people who complained, but for every bike that they sold. And then, of course, Mr. Hoker falls on August 2nd, 2020. And there was no notice given to him or any other customers of that bike as to this issue, that there were multiple complaints, or that they had decided that, according to their own words, the front forks fell below their quality standards. Nothing was communicated to the plaintiff or anybody else prior to his fall. The first communication of that sort was in late September of 2020, approaching 2 months after Mr. Hoker's fall.
It seems as though the trial court reached its conclusion because it concluded that you had failed to establish that the manufacturer, i.e. the Chinese manufacturer, knew or should have known about the defect. Seems like the case boils down to that, doesn't it?
It boils down to that, Your Honor, and I believe that her reading of that statute ignores subsection 4. This is 2847, 62847, sub 3 and 4.
And if you're right about that, then you prevail on appeal. It's remanded back to the trial court. And all these other arguments you're making here, in terms of what this particular defendant knew and when they knew it and whether their actions were appropriate, seems like that's a fight for another day.
As it being a question of fact?
Yes.
Yes, absolutely. That would be a question of fact, Your Honors. Whether under the circumstances here, the defendant acted with reasonable care, which under the statute, under the case law, would be a question of fact for the jury. I can go into why I believe the court was wrong about that interpretation. I mean, basically it boils down to subsection 4 of that statute means nothing if it's interpreted as, well, not even the court, as the defendant appellee suggests. The court didn't interpret it. The court didn't acknowledge it at all. She did not acknowledge its existence, explain why it applied or didn't apply. It's ignored, which I think she's interpreting the statute in the same way the defendant is here. However, if subsection 4 is read to only apply if subsection 3 has been met, then it has no meaning, because if subsection 3 is met, that means that the manufacturer knew, the unit complied with the state of the art, with the science, the technical knowledge, whatever, when it left the manufacturer. Okay. Let's say that that's true. Let's say, you know, a given widget, when the manufacturer sells it, the widget complied with the state of the art, the science, the technology, technical standards, what have you. But as we know, science changes, technical standards change, state of art changes. When you have a situation like you have here, where subsequent to putting into the marketplace, you have multiple complaints of a specific problem with the product. Can the manufacturer, can the seller then say, well, sorry, when we issued it, it was fine. We don't care that there was one incident. We don't care that there was 5 incidents of defective things leading to injuries. We don't care if there was 1 million. When we sold this thing, it complied with the state of the art at the time. So regardless of how many complaints we got, regardless of how many complaints we knew about, we discharged our duty by complying with the state of the art at the time. So if subsection 4 is read as the defendant urges, then it would never apply, because what that says is, what is the duty of care after the product leaves the control of the manufacturer, or in this case, the seller? And if there is no action needed to be taken, regardless of the number of complaints, type of complaints, notice of the complaints, if the product met the state of the art at the time, then again, subsection 4 means nothing. And really what that is meant to do is address situations as the situation is here, where maybe this thing was issued in compliance with certain standards, maybe not, but regardless of any of that, we know that there was a specific problem with this bike, and we know that after it left the seller's control, they have a duty to exercise reasonable care. That's under 2947(6), and just general common law principles. They didn't do that here. And that they didn't do that, I think, is a question of fact for the jury, whether they complied with that statute, whether their failure to act, failure to notify, breached the standard of care, I think it's a question of fact. But I don't think subsection 3 of 2948 precludes this claim. That was the basis of the judge's decision. I think it interpreted the statute incorrectly. And that's why we're here, and that's why we ask for reversal.
Okay. All right. Thank you.
Jason, appearing on behalf of the appellee. I want to start by showing the court that I did not coordinate with counsel about our address today, mostly because he looks a lot better in the suit than I do. So, I want to speak very briefly about the case in general before jumping to the arguments from counsel. The question that Your Honor had a moment ago about the application of 2948. I'm sorry, I keep missing these two up. 2948, and that being the basis of the court's opinion is absolutely correct. There was no evidence presented whatsoever that the manufacturer knew or should have known of any defect with these front forks, and that was fatal to plaintiff's claim as a matter of law. What I didn't quite hear from counsel during oral argument, but I think was in the brief, is the theory that subsection 4 provides that statutory bar on liability only exists up to the point that the product leaves the seller's hands and is put to the consumer's hands. And that the theory then is that because the seller failed to exercise due care in recalling these products following reports of certain deficiencies, that somehow breaches that duty of care, and that forms the basis of plaintiff's claims, which should have survived summary dismissal. The contention that was not considered by the trial court is completely false. If we look to the order, the court addresses subsection 3 of 2948, and then goes on to state that it is also speculative to conclude that the consumer complaints gave ARBA, not the manufacturer, ARBA, the seller, knowledge of the defect. That's because the dozen or so complaints, which were cited by the appellant, pertained to issues with the front forks, which were damaged in shipping. They arrived at the consumer's location. The shipping container clearly was not adequate, and the front forks exhibited damage when they were observed by the users immediately. What we have in this case was not damaged through shipping. It's never been alleged that these forks were damaged in shipping. The allegation is that these forks had some kind of latent defect that made them more susceptible to damage during use. And in that regard, there was never any kind of evidence that would have put my client on notice of such a defect that would warrant a recall before the incident occurred.
So just to be, are you acknowledging that in theory, subsection 4 could create liability for the seller after it leaves their control, but just in your particular case, there's no question of that?
I want to be very careful here. I don't want to give up an argument. I think it's such clear that it eliminates liability, but going off of what the arguments that were presented in plaintiff's brief, accepting those arguments of the law as true, then that's correct, that liability would not extend because we don't have a situation where there was knowledge on the part of the seller of such a defect of the kind that plaintiff is alleging in this case.
But if that knowledge did exist, separate liability would attach.
Yeah, I think if the facts were such that we had the dozen or so consumers that reported while riding their bikes, the front fork suddenly collapsed because of some kind of defect, and perhaps that would also require some kind of examination of that and as to what the cause of this damage was, maybe there'd be an argument there. But as it stands, we don't have that. This is someone using the e-bike outside the range of its expected uses, driving this thing aggressively in a manner that was never intended and which clearly no other users confronted because they never reported any kind of issues with the front forks from use, only from damage in shipping.
If it was damage in shipping and that was the problem, why would your client replace all the forks on all of the bikes, even those that hadn't been damaged during shipping?
So the first issue with that, Your Honor, is that those subsequent remedial measures aren't admissible in
I mean, you made a pretty bold pronouncement that all the damages were discovered upon shipping, therefore they must have been damaged during shipping. And my point is if that is in fact correct, it would seem that your client paid for forks that it didn't need to.
Well, the business decisions are the business decisions. I would say this, Your Honor, that recall was issued after this accident occurred, which I think exemplifies my client's dedication to making sure that their products were safe. And if they had knowledge of a defect, they would have reacted, right?
Didn't they order all of those parts before this accident occurred? The recall, the notice to the consumers happened after the accident occurred, but the actual order for all these parts occurred before the accident occurred. They just hadn't notified the consumers yet. Is that correct?
I apologize. I don't have the exact timeline for that particular event, how that fell in timeline and everything else. I do know that the recall order, the notice to the consumers and the recall and switching out the forks occurred after this accident. That much I can say. With respect to the additional subsections of 2947, again, they were all brought up. They were extensively briefed. I don't think that those are properly before this court. They weren't part of the trial court's order. I can address those if the panel has any questions about any of those specific subparts. For what it's worth, I think the trial court got that portion of the order wrong, but it's moot because of the dismissal on the other grounds.
Okay. Any questions? Okay. Any rebuttal?
Just one, two clarifications. One, Your Honor, it was June 17th of 20 where they purchased all of the new forks. So that was before the August 2nd, 2020 fall. It was admittedly after, if you want to call the email the recall. I certainly think the decision to replace all the forks is really the recall, which was before the incident, which dovetails into my next point is that action was referred to as a subsequent remedial measure. The decision to replace all the forks was made prior to the fall. So that certainly would seem to me to come in as evidence because it happened prior to the fall. Because both the statute and the rule of evidence talks about actions after an incident. Lastly, just one more point of clarification on subsection 4. I guess one thing I wanted to add is what that section specifically says is subsection or that section being 2948. Subsection 4 of that section says this section being 2948 does not limit the duty to use reasonable care after the product leaves the care, so on and so forth. So reading it again, as the defendant urges, not only would it limit that liability, it completely abrogates it. And
Yeah,
so
this is an argument you made before, not really rebuttal, because I don't think he brought it up.
Nothing else, Your Honor.
Okay, great. Thank you very much. All right, that matter is submitted. Turning now to item number 13, Vining Industrial Park LLC versus Homeowners Insurance Company, 374369. All right. Kelly, whenever you're ready. Good to see you again.
Good to see you, Judge. Thank you for having me. Your Honors, before let me enter my appearance. Jim Kelly appearing on behalf of the plaintiff appellants, Vining Industrial Park and Vining Industrial Park of Georgia. I did receive a communication from the Court of Appeals that there was a request for the agency agreement that was produced pursuant to a protective order earlier in the proceedings. And so I didn't want to file that electronically through the court e-filing system because then that would obviously void the protective order. So I was sort of directed by the clerk to file a physical copy along with the protective order. I do have copies for the three of you if you want to take physical copies, or we can just get those.
I don't think so.
Did you file it?
Has it been filed with the clerk?
It would, as of today, yes. Yes.
Okay.
So, so I don't know if it's been docketed or what the next process would be, but it's there. And I did share a copy. They previously had it, but I did share a copy with opposing counsel. This case is an interesting emerging issue in the area of insurance law and insurance agency law because I think the law until very recently had been oversimplified. And the oversimplification of the law is that an independent agent is the agent of the insured or the applicant rather than of the insurance company. And I think that's true as far as it goes, and that's certainly continuing to be the general rule. But under some recent and emerging case law, we have a court of appeals now that has recognized the possibility of dual agency. And so what I'm going to ask in this panel to do in this case is to recognize that recent case law and to remand this case down for further determinations on that. Simply put, I think it should be decided on a case-by-case basis. And on the facts of this case, the agent was both the agent of the applicant, Vining, during some activities that he did, and was the agent of the insurance company during other activities. I think that the trial court followed along with that, correctly identified the legal framework, found the general rule was generally the agent is the agent of the insured. And that makes sense because if you're shopping around policies, you're trying to find the best deal for the insured, you can't really say that you're acting within the fiduciary interest of the insurance company. You're obviously acting on the insured's behalf. There are other activities when you're gathering information to submit an application. You may be acting on behalf of the insured or the applicant there as well. I think in this case, the agency agreement has something to say about that. And I think it maybe changes the general rule because the agency agreement in this case says when you're submitting the application, when you're completing the application, you are acting on behalf of the insurance company there as well. So I think you're wearing two hats as the agent in that situation on the facts of this case. That won't always be the case, but I think on the facts of this case. And so we have under recent case law recognition that the possibility of dual agency does exist under Michigan law, that Michigan law recognizes a possibility of dual agency, and that there's not a carve out solely applicable to insurance agents. In any other agency relationship, you would look at the activity that the agent is doing, and then you would determine whether that activity falls within the scope of the agency relationship. And simply put, I think the same rule should hold for an insurance agent. You don't just say, okay, blanket rule, the independent agent is always the agent of the insured, and a captive agent is always the agent of the insurance company. I think you need to take a case by case approach and look at what the activity is. You also have to look at, I think, a couple of other sources, because that pre-existing body of law that I said earlier was an oversimplification. That was based on Michigan common law. I think there's statutes that apply, and the statute in particular that I would point you to is MCL 500.1208A. That's not a subsection, it's the actual 8A section. And that, to paraphrase it, basically says that the agent cannot bind coverage on behalf of the insurer unless they're the appointed agent of the insurer. And so I think we've got some statutory change in Michigan that's going to affect that common law rule. And I think we have contractual arrangements, these agency agreements that could or could not in a particular case affect that common law rule. So far, the circuit court followed my argument up to this point and went and reviewed the agency agreement. And so I was actually heartened to get the correspondence from the Court of Appeals that we want to examine the agency agreement. I had thought that it would be provided, since we did file it under seal, I thought that it would be provided earlier in the proceedings, but we've corrected that now. And I cite to several, I don't think I cite any trade secrets or anything like that, but I cite to several provisions of the agency agreement within my brief. And I would really draw the panel's attention to pages 22 and 23 of my 22, 23, and 24 of my brief. And without regurgitating those, I think that it goes through the different activities that are governed by that agency agreement and how that agency agreement establishes whether it's the agent, in this case, of the insurance company. And in particular, I would draw your attention to bind authority is found in the agency, and you're binding on behalf of the insurance company. So clearly, if you're binding, you don't bind yourself, you don't bind the insured, you're binding the policy for the insurance company. So that's a very, very easy low-hanging fruit. On the facts of this particular case, the agency agreement also says that while you are gathering information, including applications, you are acting on behalf of the insurance company. And so if the court was looking for a limiting principle to say, well, geez, if we decide in favor of binding, aren't we overturning all this case law? I think the answer to that question is no, because we have a specific provision of the agency agreement that changes this from the general rule into an exception situation. I think there's also a fiduciary relationship that's established where the agent is collecting premiums, they're collecting supplies, they've got marketing materials, they've got other things that they're holding for the insurance company. The insurance company has the ability to audit their books and records. It has a secured interest in their book of business. And so there's quite an entangled relationship here. And so you can't honestly say that the agency is a stranger to the agent. You really have to focus in on what activity is being done and what activity are we talking about. Now, in this case, the activity preeminently that we're discussing is setting the limits and then binding that policy. And so mechanically, we're done shopping around, we're completing the application. And I think you're a dual agent in this case, in this particular case. I think you're a dual agent when you're submitting the application, because normally you're doing that on behalf of the insured. But the agency agreement in this particular case does say you're also doing it, or you are doing it. I guess it doesn't use the word also, but you're doing it on behalf of the insurance company. And so I think you've got a dual agency arrangement at that moment. You then move past the dual agency to where you're binding, and now you're clearly the agent of the insurance company. And then the policy is issued and you go from there. In this case, and so I think that applying that framework and applying those facts, which really are going to be based on undisputed testimony, that is how the policy was issued and based on the terms of the agency agreement. So I think that's a question of fact, a question of law rather. I think there is no question of fact because it's established by the terms of the agency agreement largely, and perhaps maybe that term of the statute. You can rule as a matter of law that during those particular activities, Jerry Schwartz, the Schwartz agency, is the agent of the insurance company during those specific activities.
Binding, what was the other one?
The binding, and in this particular case, filling out and submitting the application. The application, exactly. And I think they're dual agents, and then when you bind, solely the agent of the insurance company. And there's no real doubt that that's the holding that should be reached, that decision should be issued as a matter of law. That establishes the existence of a duty in this case because there is no duty within the policy. So again, we have another body of law that primarily the relationship between the insurance company and the insured is primarily a contractual one, right? Because the policy exists, so that makes sense. But in this case, these activities are pre-policy, they're pre-contractual, and so we have a tort-based relationship. And so I should be able to sue for negligence because a duty exists to do these activities, and so you have a duty to use reasonable care in the performance of these activities. The duty exists, and I think the court can hold that as a matter of law. A remand is necessary because on the facts of this case, whether that duty was breached or not, that's in dispute. And so we have, if you believe Tom Owen, I asked for this policy that gives me a 250,000 square foot pre-engineered building. I don't want to replace using the existing structure. I want this different structure. And you have an agent who says, that's not what we discussed. You yourself set the limits. And then we have another agent that says, we didn't have anything to do with the limits. Those limits came from auto owners or homeowners or what have you. So there you've got a question of fact. I think ultimately I prevail on the remand because I think my client is credible, but that's not for this court to decide.
So isn't it the case that everyone knew that this was, that the actual terms of the insurance contract were for actual value and not replacement value?
Correct, that's correct.
The stick in the mud is like, well, was that going to be adequate as a practical matter in the real world for replacement?
That's exactly it. That's correct. And
that's a different, like, why, that's a different question. And like, we're going to characterize the activity and then say whether that activity is, you know, whether the independent agent is the agent of the insured or the insurer for the activity in question. Why, if that's the activity, sort of like, you know, like in the real world, this contract will be adequate to cover your replacement. Why is that? Why is the agent an agent of the insurer rather than the insured with regard to that discussion?
That's a great question. So I think that so the question is, and then the next question is the knowledge imputed from the agent who certainly, according to the plaintiff, certainly heard this information, certainly got this order, is it imputed up? And so the question is, if it's within the agency relationship, it's imputed. If it's not within the agency relationship, it's not imputed. And so your question gets to the crux of the matter and the crux of my argument here. And so when he is doing that, it was undisputed below, first of all, that the insurance company set the limits. So when we look at the policy, we've got a request here for such and such limit, $4.5 million was the original limit, and then it increased according to a cost of living adjustment. It increased over time, but the original amount was that. And so when we go back to that original conversation, The agent, Jerry Schwartz, is filling out the application. And so on the facts of our case, that's a dual agency function. He is then submitting that application, which again, I think is a dual agency. Yeah, I think generally it's you're acting on behalf of the insured, but I think on the facts of this case, I think that's a dual agency relationship. And then he's effectively sliding the application across the table to himself and hitting bind. And there, I think clearly he's the agent of the insurance company. So it's not that Vining set the limits and then auto owners agreed. The factual scenario is that auto owners, the homeowners is the underwriting company. The witnesses previously referred to it as auto owners. So I'm stuck in muscle memory on that. But the insurance company in this case issued those limits, set those limits, and that was the finding below. That was the undisputed fact in the case. So that is a auto owner's function or a homeowner's function. I'll reserve for rebuttal.
All right, thank you.
Thank you so much.
Jason Osmer, appearing on behalf of the defendant appellee. I'm going to start with my second point first, since Your Honor raised this with opposing counsel here. This is an interesting case, I think, because we have a not plaintiff, but the owner, Mr. Owen, who is a sophisticated user, so-called. He's not someone like me who just goes to the insurance company and tells them what my house is, and they say, well, here's your coverage, and I go about and have fingers crossed, hope nothing bad happens. Here's a guy that specifically knew, I mean, he was very clear the difference between ACV versus replacement cost. He knew the value of the building. And frankly, he's the person in the best position to put a value on the building, what it would cost to rebuild if such a unfortunate event happened. And so to now come before the trial court and now before this court to say that, well, he relied upon the representations of his agent to say that the policy was sufficient, knowing full well what it means to have an actual cash value versus policy versus replacement cost value, knowing that he wanted to replace the building in the case of a loss. I think there are issues with that, right? Essentially allows an insured to, who knows full well what a policy is going to pay out in the event of a loss, to ignore that knowledge of fact, and instead rely upon the representations made upon made by the insurance agent, which may be incorrect, and say, well, okay, I'm happy to pay the lower premium for this actual cash value, but when the time comes for a loss, I'm going to demand the replacement cost because that's what I want. So he's manufacturing a discount essentially on premiums to accomplish that. That kind of misses, I think that's important for context, but really the point of it is really what we're all here to discuss, and that's the interplay between a captive agent and independent agent. And I appreciate the nuance expressed by counsel. I do think it requires careful attention to the details to make these determinations, but I would push back on the concept that this is a new development of the law. I think that the law in this has been fairly well established and adequately addresses the facts we have before the court today. And looking in detail as to the function of this insurance agent relative to the insured as well as the insurance company, this agent very clearly falls within the category of independent agent. In addition to auto owners, Schwartz Insurance Agency represented, really offered policies through Pioneer, Hanover, Fremont, Progressive, Promotion Insurance Company, and Haggerty. That's what's listed on their website. Who knows how many other insurance companies that they can also sell insurance through. And for all of and so in that regard, they cannot, as a matter of logic, be beholden to any one insurance company. They're working on behalf of their clients, the insureds, to sell them the policy that best fits their need through this slew of potential insurance companies. So in terms of the relationship with the insurers, there's no question that in certain capacities, Schwartz acts as an agent of auto owners, the same as they do for Pioneer, Hanover, Fremont, for these specific activities, which were described by opposing counsel here. The two he noted, the authority to bind the insurance company to a policy, the authority to complete an application and submit it to the insurance company. Those are activities that fall within the scope of the contract with homeowners, and I'm sure any number of other agencies. And this is a standard contract. The question that is essentially what the plaintiff's arguing then is that that responsibility somehow converts this insurance agent to an agent for the insurance company for purposes relevant to this case. And it simply does not, right? Binding an insurance company, soliciting business on behalf of an insurance company, quoting a policy, selling a policy, accepting a policy, all on behalf of an insurance company. These are all activities that fall squarely, that were specifically addressed in the cases of Al-Hajjaj and Genesee Foods, in which it was found that the insurance agency was an agent for the insured for the relevant purposes, not a captive agent. All right, these are all, this is binding precedent that we have to follow. What I hear the argument being put forth is that, so I think they address the binding component of it. I don't think there's any specific language in those two cases regarding completing the application, submitting the application. And what I hear Brother Counsel saying is that those activities are outside the scope, right? Or are activities taken on behalf of the insurance company, and that those activities somehow extend to a vehicle by which liability can be imputed to the insurance company when the policy didn't live up to the plaintiff's subjective expectations. I don't follow the logic on that. And the problem I have with that is that completing and submitting the application are not components where there is any kind of advice provided to the insured, right? This is a bookkeeping routine matter. The agent is an agent for the insurance company for these activities because the insurance company demands that this information is reported accurately and that they can rely upon it, right? But the question I would put is what happens, where does that information come from that is put onto the application and submitted to the insurance company? How do we know what answers, how does the insurance agent know what answers to put on there? Those answers come from consulting with the prospective insured as to their needs, their desires, their wants, their intentions, and the interaction of what is sufficient coverage based on those needs. All of that happens before the application is completed, before the application is submitted, and all that activity is done for an independent agent acting as an agent for the insured, not the insurance company, right? That's the difference between a captive agent versus an independent agent. Captive agent is a salesman for a particular insurance company. An independent agent is a representative of the insured for selling him the policy that best suits his needs, regardless of where it originates from. So for those reasons, I think the trial court had it absolutely right. I think the order on the motion for reconsideration by Judge Benson is extremely thorough, and is it certainly was the guiding light for me for preparing the response to this and preparing arguments today. I think that was a correct decision by the trial court, and this court should affirm.
Okay, you're all set. Thank you.
Thank you.
All right. Any rebuttal?
We heard that Tom Owen was a sophisticated user who was the best person to put a value on the building. If the agent or if auto owners had simply told him that, he could have gotten his own estimates done and we would not be here today. He would have gotten more insurance. He would have gotten insurance that was adequate, and he would have only himself to blame if that didn't happen. That's not the facts before you. In this case, auto owners said, we've got you covered. We have you. This is the policy limit that we've got. Tom Owen testified that Jerry Schwartz assured him repeatedly that underwriters from auto owners had done an analysis and had determined that these limits were adequate to do what Tom Owen wanted to do, which was replace with a different size building, a different shape, more cubic feet, but a smaller footprint, going from a 300,000 square foot building to a 250,000 square foot building. And so auto owners could have rejected the risk if they didn't have enough information. Instead, they accepted the risk. They set the limit and they put a value on this building. They didn't say we can't do that, or we don't know what you're talking about. We don't have enough detail. And so because of that, whether Tom is a sophisticated user or not, I think that auto owners has some liability there. This is not a case where Tom Owen or Vining now have buyer's remorse because they bought an actual cash value policy and now they had a loss and they realized, okay, shoot, we should have gotten a replacement cost policy. That's not the facts of this case. The facts of this case were very clear that Tom Owen asked for a policy with sufficient limits to replace this type of building. There were conversations about their long-term tenant, Keystone Automotive. Jerry, after the fire, the agent wrote emails that said, yep, we understand that the goal of this policy was always to put you back in the position that you were going to be in, you know, so that you could keep the cash flow going, keep the tenant going, is the unstated part of that email. But that was the understanding. And that's what Jerry Schwartz's deposition testimony was. Yeah, I knew about the tenant. I knew that you would want to keep the tenant going. That's exhibit G and H to my response, or the plaintiff's response rather, to the summary disposition motion filed below. Again, we're dwelling in the exceptions. We heard that the independent agent cannot be beholden to any one insurance company. Certainly that is true while he's shopping around and trying to find the best deal possible for the insured. That's why the general rule is what it is, that it's the generally agent of the insured, of the applicant, not the insurer, the insurance company. But once that function ends and we shift to a different function, we now need to look with a fresh set of eyes. This is my contention. We now need to look with a fresh set of eyes. And I think that the Opera Block Properties case agrees with that. I think that's adopts the restatement view that yes, in this context, in the insurance agent context, you can have dual agency. And so Michigan law recognizes that. I thought, and I nodded when opposing counsel said that the trial court's decision, particularly on the motion for reconsideration, was very thorough. There's no doubt about that. But the judge refers to in that decision a standard contract or the contracts that were present in El Hajjaj or Genesee Food Services. And the truth is there is no standard contract. We don't have those agency agreements. They're not available to us. There's no reason to think that every agency agreement is the same. There's actually every reason to think that every agency agreement is different. That's why it was produced under protective order, because there are trade secrets and company specific information in there. And the particular relationship between this particular group of insurance companies and this particular agency is what's at issue. There's not a blanket rule that we can assign to that. The only other point that I would add is that counsel said that there's no advice when submitting the applications. It's just a routine mechanical thing. It should be, but we would all agree that if you ask for X and you get Y, that there's somebody screwed up something there. And the question is, well, who did it? And so in this situation, Vining asked for a policy that issued limits for X. They got a policy that issued for X minus Y, a lot less than X. And the question is, who did that? That question has been answered both by this court previously, by the lower court, by the parties themselves agreeing. It was auto owners that did that because auto owners set the limits. So with that, I will ask you to decide the case in my favor and issue the remand. Thank you.
All right, thank you. That matter is submitted. Turning now to item number 14, that's SKF versus ED Junior. It's item number 375842. You can actually approach the lectern directly, because I think you're the only person who's endorsed. And if you could please state your name.
Yes, my name is Edward DeFilio, and as you can see, I'm the pro se appellant in this matter.
That's right. Can I just interrupt you just for a moment? Because I know, because you're representing yourself, just a couple of quick ground rules.
Yep.
That's all right. Because you are endorsed and there's no one endorsing the other side, you probably know this already. You have 15 minutes, up to 15 minutes. Okay. And obviously this case turns on two issues, right? Whether the initial PPO or the PPO should have been granted in the first place. That's item number one. And then the second issue is whether due process violation because the trial court interfered with cross-examination of the petitioner.
Yes,
And then the last issue I'll just simply note
okay.
is that I know you've been here all morning, you were watching us, and you may or may not recall the attorney that was up here who was a trial attorney, and he was kind of talking like a trial attorney. We're not trial judges. We're not who you were from before. The real question for us is whether the trial court judge made a mistake that warrants reversal, not.
Yep, I completely understand that.
Okay, perfect.
If you will, again, I did as much research as I possibly can.
Great job.
And if I can add, there's a few other things that I found as I was going along that if possible to add to it, like constitutionally protected speech, which I found in a Michigan court appeal.
Kind of stuck with the two issues that you've raised though.
Oh, okay. Well,
yeah. You can't, we're not that quick on our feet that we can jump into constitutional questions right now. But so I just wanted to, this is not cut into your 15 minutes. But I just wanted to sort of get the ground rules down straight.
Nope. And I appreciate it, because if I have a couple seconds, I was just totally disappointed in how the trial court ran before. It just, it's not what I expected as justice. That's all I will say.
Okay, go right ahead. Once you move forward through your issues, go right ahead.
So I'll just keep to the PPO and the due process part, correct?
Yes.
Okay. So the first part I'm going to say with the whole concept of the emergency ex parte, and I'm going to kind of read what I prepared here. As going through my research and stuff, I started to question things. So I asked on 2 separate occasions a clerk over there. I don't know if I can give you his name or should I leave it out?
Doesn't matter.
Okay. Michael Miller, he's been there for over 6 years, and he had stated to me that all PPOs processed by the Kent County are processed as ex parte PPOs, which begged another question, which I'll get to. So based on that, it's my contention, based upon Hayford versus Hayford, that such actions by the county and or court, because I don't know how that all works, that they violate the state law and the principles of due process, not to mention an abuse of power and discretion by the trial court. First, it falls outside the range of reasonable outcomes.
This is the notion that all PPOs are done ex parte. Is that what your point?
And that's
all right. Well, and that's I think the threshold question is what did the trial court get wrong in terms of granting this PPO?
Well, okay. So where they got it wrong, I got to regroup now here. Okay. And I don't know, see, because I'm all flustered now, so bear with me.
Take your time.
Yep. So in regards to, I guess, certain things, I look at it, what they did is circumvented the law by violating the concept of fundamental fairness guaranteed by the due process clause of the 5th and 14th Amendments, as well as Article 1, Section 17 of the Michigan State Constitution, which guarantees individuals fair and just treatment. In Snyder versus Massachusetts, the Supreme Court stated that the practice or rule violates due process if it offends some principle of justice so rooted in traditions and conscience of our people as to be ranked as fundamental. The ruling established that a practice is a violation of due process if it is so against the established principles of justice and tradition in the U.S. that is considered fundamental.
So I think I would agree with you if this was an ex parte order and there was no hearing at all, ever. I see your point. But here there is an ex parte order. You challenged it.
Yep.
Then the court held a hearing. I know you don't like how the hearing was conducted, but there was.
If you want to call that, we'll say it.
Yeah, you got in front of the judge.
Yep.
There was some back and forth. So tell us what the trial court got wrong at that hearing.
Okay. I'll just go to, because I can't.
I mean, you can spend your time how you want. I'm just telling you that's the important part, I think, for us.
Okay. because I can't do the Constitution. Well, okay, I'll start with the thing that the judge brought up in particular was MCL 750.411S, which addresses the posting of messages through electronic medium, including the internet or computer or other electronic medium in communication. So this is where I got a concern. So I'm just going to read it and you can tell me to zip it, if you will. I'll cite it that way. In citing TMZ versus MZ, the Michigan Court of Appeals stated that 750.411S does not prohibit constitutionally protected speech or activity. Speech over the internet is entitled to First Amendment protection in the same manner as traditional speech. And I referenced a Cooley Law case, whatever the site in Reno. I won't get into that. Constitutionally protected speech includes all speech except that falling into certain categories, including defamation, fighting words, words inciting imminent lawless action, and true threats. The emails or speech did not amount to fighting words, words inciting imminent lawless action, or truth threats. The court also stated that it is not enough to show that words amounted to harassment or obnoxiousness. Furthermore, my emails were never intended to cause conduct that would make the victim feel terrorized, frightened, intimidated, threatened, harassed, or molested. I contended that that being protected and also my emails were qualified as privileged communications because they attacked my character and reputation. And then the stuff that I did send was all factual behavior based on our platonic relationship. 754.411S1C says that and did cause the victim to suffer emotional distress and feel terrorized, frightened, intimidated, threatened, harassed, or molested. And if we look at the totality of the circumstances with the petitioner over the years, her words, actions, and deeds presented in my motions contend that no reasonable person would conclude that she suffered from emotional distress or feel terrorized, frightened, intimidated, threatened, harassed, or molested. Then again, furthermore, 411S does not prohibit constitutionally protected speech or activity. You're probably aware the court concluded that in order to warrant a PPO pursuant to 600-2950A1, the trial court had to find the respondent's postings or my speech were not constitutionally protected. Then I'll just briefly touch base because this is what I put in the appeal. The judge never took into consideration the totality of the circumstances. All the stuff that I had in the motion to terminate and what I was prepared to present, he just focused on an email that is in reference to her behavior and stuff and my response to hers, an email when I attempted to reconcile, and a thank you card. That was all he focused on. There was all kinds of other things that demonstrate that this wasn't harassment or whatever else, okay? And I won't get into the court cases because they're already in the brief, Patterson versus Breverick, whatever, however you say that. And then denying me due process. I was never really given the opportunity to be heard by the judge. He cut me off and I reference it in the transcript, the lines 9 through 11 on page 5. There's other times on line 23, page 5, lines 9, 25. When I attempted to interject, he just basically cut me off and said, I'm making a ruling here. So how can you defend yourself if you're not allowed to speak?
Can I ask you a question about that?
Yes, sir.
If he had not cut you off, what would you have said or done? And how would that have made a difference in the overall case?
Because what was being presented was one, an image that I sent her a while back because we joked about things. And then there was another issue where the petitioner said that I forced my wife into doing something, which I did neither one of those things. So then it would allow me to bring up some other things that were addressed, like, why didn't you consider this? Or, and then, which kind of leads to, I guess, the cross-examining her, because there were things that I could have brought up that would have completely negated her arguments that were being made, which were very limited.
Do you have any examples that you can?
Yes.
tell us?
Here's an example, like, at one point in time after her, well, I won't get into details, but her sexual innuendos and such, okay? I told her I needed to take a step back for my own mental health. I have PTSD, depression, anxiety. Part of it is from my military service, which also includes military sexual trauma, okay? So I wanted to take a step back. After that, she came after me kind of nasty in front of other people as well, okay? And then there's other things where, to show that we joked about stuff, like, you've heard of the acronym FWB. Want me to just say it out loud?
No.
Okay, you know what I mean?
Sure.
Okay, well, I joke because I baked cookies for her to bring into her staff. And I said, you could tell your friends they were baked by your FWB, your friend who bakes. That's the kind of stuff that went on back and forth. And all the other things that were done for her, with her son, it would have painted a picture that there is no way that I harass her or there was ever a threat, which is part of the statute. There was never any sexual assault. There was never any sexual, I don't know, I can go back and read what it says, but there was none of that one bit whatsoever. And what it appears on the surface, hindsight being 2020, because I'm rather ignorant with certain things, it was almost like, and this is what other people told me who I confided in, is that I didn't acknowledge or go forward with her advances. So therefore, she became this person. And then when it comes time down to when the petition for the PPO occurred, this is what happened. And I got it documented. For over 296 days, 9 months, I walked around the block, which is the block I've been walking around for over 5 years. Never an issue. When she didn't like what I wrote in the email, she started to avoid me when I walked around the block, which I just, okay, that's fine, that's on you. She would call her son into the house if they seen me. She would drive in a different direction. She seen me walking my dog. She seen me, which, and again, goes back to how else would you argue this? She claims in the PPO that I followed her into Palmer Park. Well, it was a routine that I walk my dog into Palmer Park. Actually, a couple of weeks before this all occurred, she was walking out, I was walking in. So we crossed the street from one another. So on precise date, April 6th, I walked my dogs around the block twice. The first one, her son talked with me, which wasn't something that, was permitted before, which he talked with me a couple of weeks earlier. And there was another neighbor that my wife and I know, sitting in a driveway, and I joked with her about this little shopping excursion that my wife and the neighbor had. And I just said, "How you doing, Shauna?" She said, "Good." So then I pick up my other dog and I walk my dog around the block. This is a puppy that she hadn't seen for a while. And she's like, "Oh, how cute," whatever it is. And the puppy is dragging me up the drive. Doesn't say a word, very cordial. 3 days later or 4 days later, I take my dog out for a walk, and you have to, I'll just draw it this way, okay? So this is the block. It's like a circle. I live over here. She lives over here. There's houses dividing the block, okay? How do I know that she's taking her dog for a walk at the same time I'm taking my dog for a walk? So she comes around this way and is headed towards Palmer Park. I'm about 300-400 yards back from her, and that's where I was going to take my dog for a walk. Well, what it boils down to is she calls a neighbor and brings in these strangers saying that I'm stalking her. Okay, and then she sends a nasty message to my wife.
So just to just two things. First,
Yep.
you got 2 more minutes, but
Yep, yep.
one of the challenges that you have in this case is that, at least with regard to the first issue,
Yes.
is that she testified things like, he's following me, I'm fearful, I'm scared. Put that in one column.
Yep.
And in your column, you're putting together your arguments, which you say outweigh her arguments or show them to be false.
Yes.
Right? Okay, that's fine. The problem that you have, and at least in this court, is that we have to conclude that the trial court plainly erred. Not like, if we were the judge, we would have weighed them differently. It's plainly, clearly is wrong, not just wrong, but clearly wrong. And the judge is the one who weighed the credibility, saw people, we didn't see anyone testify, we're reading transcripts. We're not evaluating credibility. That judge did that. And we have to say, in the weighing of that credibility, not only did the trial court get it wrong, but was clearly wrong. That's the challenge you have in this court.
Okay, and I kind of understand that, okay, and I'm just gonna, we'll say to the extent, play devil's advocate here with this, is when I go to try to interject, okay, and I can't interject.
Yeah, that's a different issue. That's the second issue.
Yeah,
Right,
okay.
right. That's why that second issue is a stronger argument here. I'm not saying it's a winner.
Right,
I'm
right.
just saying it's a stronger argument here than the first issue.
Yeah.
That's all I'm
because,
saying.
Again, I guess that if I understand you correctly, okay, and if I wrote it up correctly, okay, there's really I'll say three issues here, okay? And maybe they all three are due process related or the other two are due process related. I was never given the opportunity one bit whatsoever to cross-examine. I was never given the opportunity to, we'll say, fully plead my case because I was cut off. Which then I'm going to say indirectly goes back to analyzing totality of the circumstances. If I can't present anything, how can you make a decision?
You're going to hate what I'm going to say next is that I've got to cut you off because you've hit your time allotment. So
I understand.
I'm kind of in the same spot, but hopefully you feel as though you've had a better opportunity to be heard here. So do you want to just wrap it up?
Yeah, no, I just, my personal conclusion of this is that I wasn't given a fair shake one bit soever by the judge. And that's all I appealed it for and am asking for, because if I can say this and if you want to count it off the record or whatever it is, when I walked into that case, it was almost like the decision was already made. And there was nothing that I was going to be able to say or do. It just, if you would have seen his mannerism and how, I'm going to say, if you look at the transcript, he was rather terse. And it's like, geez, this is what justice is supposed to be? How do you expect to defend yourself when, again, everything that I read about a hearing like that, it's supposed to be conducted like a regular hearing. You're allowed to be heard. You're allowed to cross-examine. You present the case, which would be the totality of the circumstances. And none of that was taken into consideration.
Well, let me at least tell you what's going to happen, at least here. We're going to have an opinion. It's going to be written.
Yep.
It'll be distributed. You'll be able to see our thoughts, why we decided the way we did. And then you can take that for what it's worth.
And if you will, lesson learned next time, make sure I put in those protected speech things and everything else.
Yeah, you got to, yeah, definitely. Put it all in.
But
No surprises at oral argument.
Yeah.
All right.
But I want to say thank you. This was a much better experience. I feel like at least I've been heard, not a number. So
you're welcome.
Thank you.
We're with the government, so we're here to help.
What's that?
Nothing.
I heard what you said.
All
I used to work for the government.
We all do.
Social Security manager and then as a nurse at the VA. So
all right.
I'm well aware of that.
All right. Take care.
Yeah,
Good luck.
Happy New Year, by the way, also.
Happy New Year.
Thank you.
All right. That matter is submitted. Turning now to item number 15. The last case on the docket today, in Ray West Minor. That's item number 376415. No one is endorsed on that case, therefore the matter is submitted. That concludes today's docket. Thank you very much.